Good morning. My name is Hayward Dykes. I'm the special magistrate. I'll be handling the cases this morning. I'm going to call to order the court docket for November 12th, 2025. As I said earlier, if you have a cell phone, please turn it on vibrate or turn it off. At this time, I'll go ahead and swear everybody in who plans to speak this morning. So anyone who plans to present testimony or evidence, please stand and raise your right hand. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. You can have a seat. First case we have on the docket is GI Jade Water Sports. That citation is CE 01114. The this is a rehearing. Is there anybody here for GI Jade Water Sports this morning? This matter was heard a couple months ago. There was a request for rehearing based on the recording, the hearing not recording the way it should have. So we've set this up for a rehearing. All right. Did notice go out too? Okay. So clerks confirm notice for this rehearing. I don't see anybody standing. Officer Busby, whenever you're ready. All right, I've been handed from Officer Busby the case activity report for BCE 25-22-894. Has a narrative on the first page, picture of a blue or teal colored pontoon boat. I recognize the area as being at the boat landing, Cessna boat landing.
Yes, sir.
And then we have a copy of, with a highlighted portion of a definition for commercial activity, means an activity intended for exchange in the market for goods and or services to earn an economic profit. And then there's the last page is section 24-2 of the Walton County Land Development Code, or code, is that correct?
Yes, sir, for the
right.
The boat activities.
Right. Okay, I just wanted to make sure that was from that section.
Yes, sir.
All right. And then the definition I just read from for commercial activity, is that also from the Walton County Land Development Code, or is that from?
This from the, from the 24. It's from our ordinance, yes, sir.
Okay.
22, chapter 22, I'm sorry.
All right, I'll accept this into evidence. What additional testimony or evidence do you want me to consider, Officer Busby?
I do have body cam footage from that incident if you need to see it.
Is it the same body cam footage that we saw last time?
Yes, sir.
Okay. I recall the body cam footage that was, I'll provide that in the event this matter's appealed, that body cam footage will need to be made part of the record and put into evidence. So don't delete that or
yes,
allow it to be deleted, at least through the appellate period allowed. All right, what additional testimony would you like me to consider this morning?
I don't know if you want me to just to read off my report from that
Yeah,
day.
if you want to go ahead and do that, just so we can make the record clear, since this is a rehearing. While I can acknowledge certain things from the last hearing, I would rather you go ahead and make the record this morning.
Yes, sir. Officer Busby, Walton County Code Beach Supervisor. While on patrol at Cessna Landing, this was on 4th of July, I observed GI Jade Water Sports pontoon arrive and tie off at the dock. As I approached the boat, the gentleman there stated that he was glad I was there because he wanted to talk to me. We engaged in conversation. He then stated that what we were doing was wrong, that he was not running a charter but supplying a rental. I explained to him the county ordinance, and he rebutted that he did not need a permit per our county attorney and our office manager, Ms. Kim Jones. I again told him he was incorrect in that, and I was going to issue him a citation. Upon issuing the citation, I asked him if he was going to sign it, which he responded, F no, I'm not signing that. Also, while having the interaction, he was verbally belligerent, causing the scene at the access. Citation issues, citation number 1114.
And the alleged violation is for a violation of 24-2 for commercial activity. What commercial activity are you alleging occurred?
He was chartering a pontoon rental from the county docks without a permit.
All right. And how did you come to that conclusion?
They are required to be put on the actual vessel itself, and there was none present. And again, in conversation with him, he just flat out told me he didn't have to have one.
All right. Did as far as, did you make any contact with anybody else?
I did. After I issued him the citation, I went back to my vehicle just to kind of wait and see if the party arrived. Once they did, I met them before they got on the vessel and talked to them, and they did indeed admit that they had chartered the vessel.
Did you see those individuals, I guess, board the vessel?
Yes, sir,
and
I did.
Leave the landing?
Yes, sir. And while I was speaking to them, I do have body cam footage of this. Also, my interaction with the ladies getting on the boat. He was in the background telling them they didn't need to be speaking to me. That just needed to walk away. He didn't want them to have any interaction with me.
Okay. All right. Anything additional I need to consider this morning?
No, sir. None that I can think of.
All right. Thank you, sir. I didn't see anybody come in, but I'll do one more request. We are about 6 to 7 minutes behind, or more than that. We're supposed to start at 8:45, aren't we? Yeah, so we're almost 20 minutes past when this hearing was noticed. All right, so I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the evidence presented, as well as the testimony provided by Officer Busby, that there is sufficient evidence to show that infraction occurred, a violation of Section 24-2 of the Walton County ordinances. Based on that, there will be a $500 code enforcement fine, a $50 clerk administrative fee, and a $25 clerk processing fee for a total of $575. That amount will be due within 30 days. I've signed that order, and I'm providing the clerk the what I've marked as Exhibit 1 for that. And then, as I said, Officer Busby, just be sure to go ahead and save or keep that video or body cam footage in case there's an appeal of the infraction.
Sure.
All right. Thank you, sir.
Thank you.
All right. Our next case is 25-3408 MG. The party is listed as Thomas Hillman, Hilaman. Is Mr. Hillman here? All right, Mr. Hillman, if you want to come on up, you can take a seat at this this table right here, that flat table. What we'll do is I'll allow the officer to present any evidence or testimony he wishes to. You can question the officer if you like, and then you can present after that any testimony or evidence. I would just ask that anybody, and this is for Mr. Hillman or anybody else, whenever you come, just come to the podium and speak into the microphone. That whole time we were waiting earlier was so we could go ahead and key up the video recording as well as the audio recording. So we try to speak into the microphone best we can. All right. All right. I believe the officer who's handling this is Officer Ford.
Yes, sir.
All right. Good morning, sir. You've been sworn in, and whenever you're ready, you can proceed.
Good morning. I'm Corporal Ford with the Walton County Sheriff's Office. On September the 20th at approximately 11:30 during a routine patrol, I observed a vehicle parked in a signed no parking area in violation of Section 2023 of the Walton County Code at the intersection of Fort Panic Road and West 30A. I exited my vehicle to take photographic evidence of the offense, which I'd like to submit as exhibit for the county.
All right. Have you shown Mr. Hillman a copy
I have
of that?
some copies.
Okay. Yeah, please provide those to Mr. Hillman, and then you can approach. And Mr. Hillman, just review those. If you have any comments or anything like that regarding the photographs, you can let me know when it's your turn to speak. But I've got 3 photographs that have been handed to me. I'll allow Officer Corporal Ford to speak to them, but what I see is a picture of a roadway with a Chevy truck with a Florida license plate. The truck is black in color. There's 2 photographs with it, and then there's just one of the road. So do you have those 3 photographs? All right. Do you have any comments, sir, or anything? Okay, thank you, sir. All right, I'll accept these into evidence as a composite Exhibit 1. And Corporal Ford, go ahead whenever you're ready.
So as the photos demonstrate, when I exited the vehicle, I observed that the subject vehicle was parked fully on the county right-of-way in a signed no parking area, and was also creating a nuisance to the traveling public against Section 2044, in that it was parked within an intersection obstructing the vision of oncoming traffic. I then issued the citation in accordance with our standard procedures, placed a copy on the vehicle, and resumed patrol without incident.
All right. So as you indicated, no contact with the vehicle owner. Therefore, all right.
That's correct.
Mr. Hilleman, am I pronouncing that correct? Holloman, do you have any questions for Officer Ford at this time regarding either his testimony, the photographs, anything that you... Okay. All right. Well, then we'll have him take a seat, and if you want to come on up to the podium, sir, I'll be glad to hear any testimony or look at any evidence you may have.
All right.
Good morning, sir. Yeah.
My wife and I went to the beach that day. We drove through Fort Panic parking lot. I could have parked in a handicap. I got a handicap sticker. I was feeling good. I have health problems. And I said I just left it open so someone else that might need it worse than me. And drove around, and when I drove out of the parking lot, the way I was headed, the way that no parking sign's turned right there, it's turned toward 30A and not toward where I turned in to park. Did not see it. And I parked there the whole summer going to the beach. And you can see in front of it, there's a lot of vacant land in front of my truck there. Cars parked there all summer long. I believe there needs to be no parking signs all in that little triangle area so people won't park there, period. Because it's almost like a trap. I mean, you got all that land on the side of my truck, and where I park's wide open with no parking signs there. I mean, I'm not going to park somewhere where I didn't think I was going to get a ticket.
Right. Officer Ford, is this where he parked? Is that part of the county's right of way, or is that private property?
So the Exhibit 1, Photo 1, you can see the power lines. The power lines mark the edge of the county right-of-way. That white wall that you can see in the distance there, that's the private boundary of the property in that intersection. It's a very weird piece of property. 42 Fort Panic extends all the way to the stop sign.
Just give me 1 second.
So Mr. Holloman is partially correct. Had he gone forward about another 2 car lengths, he would have been on Fort Panic Road, which is a private road and is not enforceable. However, he was parked fully on the county right-of-way, and that is a violation of Section 2023.
It's just real deceiving.
Understood, sir. Just give me 1 second. Yeah, okay. And I've pulled up the property appraiser's website. So yeah, that is kind of a weird layout. There is private property there. And there is a county right of way. So the issue we're dealing with is parking in the county right of way when there's traffic control device that says no parking. And Mr. I keep wanting to say Hilleman, is it?
Holloman.
Holloman, I'm sorry. Mr. Holloman, I can understand your issue with the parking sign. I can tell you that I've had other individuals before me, and they complain if the parking sign's turned the other way because then they don't see it.
Well,
and
it's
then,
the arrows are pointing parallel with
Right.
30A, so it's not saying 10 feet, 20 feet behind the sign. It's just pointing. You know, all the signs, no parking signs there are pointing toward 30A with the arrows. Don't park in between the signs.
No, I understand the signs, and I think what I was looking for was what Mr. Ford.
Now that I see what he's talking about, yeah, I didn't know that.
Yeah, well,
I mean,
and that, and
he's
again,
correct. I'm wrong, but
no,
it's just deceiving.
yeah, I don't know that I would characterize it as deceiving, but I can understand where someone could get somewhat confused. But I think to your point, had you parked a car length to your left, if you're sitting in your driver's seat, then you win the case today. Unfortunately, you didn't, and I understand, you know, why you might have come here, you know, wanting to address this. So, but yeah, I understand. Is there anything else that you would want me to hear? Any
No,
other
sir,
testimony? Okay.
it's pretty.
Yeah, I understand. I agree. I don't think it's very complicated. You know, I understand Officer or Corporal Ford's. He's a good officer. He's been
Oh, I
before me
can see
several
his point
times.
now that he pointed that out.
Yeah.
Absolutely.
Understood. And I mean, that's why I wanted to know, and I asked the question because I was curious. Because if you're on private property, then I don't have anything to say about that. You know, that's not my job. But we do have the issue about the parking in the right of way. So, all right. I appreciate it, sir. Unless you have anything else, I'll go ahead. You can grab a seat. Corporal Ford, anything else?
No, sir.
All right. Thank you, sir. This time I'll close the evidence portion. I'll accept in the evidence the composite exhibit photographs 1 through 3. Based on the testimony and evidence presented, I do find sufficient evidence to find that an infraction has occurred. While I understand Mr. Holloman's argument and concerns, you know, I've dealt with these several times. I understand, you know, if we put the sign the other way, there's only so many signs the county can put out. It's an unfortunate thing. But what I will do, I will reduce the fine from $100 to $75 to give Mr. Holloman a little bit of a break. There will be a $50 clerk administrative fee, a $25 clerk processing fee. So that'll make the total due $150. Mr. Holloman, can you pay that within the next 30 days? Okay, you'll have a copy of the order. If you want to pay it today, you can. Otherwise, you'll have 30 days from the date of this order to pay that. And I've signed that order. You'll get a copy if you'll just give the clerk 1 second to get it to you. All right? All right, that'll conclude that case. Officer Ford, do you want to stick around or do you have another case? All right. Our next case is 253195 MG. The individual listed as Ashley Weaver, Weaver, and we have Officer Murphy, I believe. Officer Murphy, are you?
Yes, sir.
Okay. Do we have Miss or Mr. Weaver? Okay, I don't see anybody standing. All right. Officer Murphy, you were sworn in earlier, and whenever you're ready to present, go ahead.
Yes, sir. I was on patrol on August 23rd. I was in what we call District 4 Bravo on 38, and I received a dispatch call to go to an illegally parked vehicle in a handicap spot at the Publix and Water Sound. It took me about 20 minutes to get there from the location I was at. I expected the vehicle probably not to be in the location when I arrived on scene. And in fact, it was, Your Honor, and I took a picture of it. And I got out of the vehicle, my vehicle, and I looked to see if it had a handicap placard. I looked also to see if it had a handicap license plate, and it had neither. So I took a photograph of it, and I wrote violation of County Ordinance 2012, parked in handicap spot without a placard showing and no handicap license plate. And I have a photograph, sir.
All right, if you, you can go ahead and approach him. All right, thank you, sir. All right, been handed a photograph of a white GMC Yukon with a license plate A2TB, B as in boy, E, and Y, and it's an Alabama tag. All right, so looks like the windows were down or partially down. Is that?
Yes, sir. The window was down on the driver's side, which I thought was rather ironic, being parked. And I looked on the dashboard, because sometimes they don't hang them up. They put them on the dashboard. And I also looked in the center console, because sometimes they will leave them there, and I did not notice one.
Okay. All right. I'll accept into evidence what you presented as Exhibit 1. Is there anything additional besides the citation or in the testimony you've provided that you wish for me to hear this morning?
No, sir.
All right, thank you, sir. You can grab a seat. At this time, I'll close the evidence portion of this hearing. Based on the testimony and evidence presented, I do find sufficient evidence to find that an infraction occurred. Based on that, the fine will be $250 for violation of parking in a handicap parking space without placard displayed. $250 fine, $50 clerk admin fee. Is there no clerk processing fee?
It's included in the $250.
Okay. So the total will be $300. That'll have Miss Weaver or Mr. Weaver will have 30 days to make that payment, and I'm signing that order now. All right, our last case, did you say this was an add-on or just didn't print?
It didn't pull.
Okay. Do I? Oh, you got that citation. All right, the last case that we have is 2500 3001 MG, and this is listed as Dylan Wagner. Is there a Mr. Wagner here? Okay, Mr. Wagner, you want to come up? Are you here for something, sir? Or are you just watching? Which one are you? Because this shows as our last one. Oh, are you here for the other code? Oh, okay. All right, understood. That's fine. Just wanted to make sure you weren't sitting. Yeah.
Morning, Your Honor.
All right. Good morning, sir.
Yeah, Brooke.
Yes, sir. Thank you. All right. And Mr. Weaver, or Wagner, I'm sorry. If you want to, did you provide Mr. Wagner a copy?
I did.
Okay. Yeah, if you want to look through that, I have provided a copy of the citation, a photograph, a printout for a vehicle search. Looks like a printout for the code section, and then some additional 2 photographs after that. I'll allow the officer to go ahead and present, and then if you have any questions or comments about it, I'll hear those here in a moment. All right. All right. Go ahead and grab a seat, and whenever you're ready.
All right, Your Honor, I was patrolling the area of Ed Walleen Regional Beach Access parking lot area on August 5th, 2025, when I observed red in color LSV low-speed vehicle parked outside a marked space. I issued a citation 6268 or CE 06268 for being parked outside a marked space.
Okay.
Afterwards, I attached the citation to the vehicle.
All right. All right. Mr. Wagner, do you have any questions for the officer, or do you have anything you want me to hear regarding the evidence that the officer has presented this morning?
I did have one question,
Sure.
as well as a testimony that I'd like to provide, if that's okay.
Yeah, go ahead and ask your question first, and then we'll have your testimony.
The question that I had was there any other pictures taken showing the environment where my vehicle was parked, specifically that entire parking lot and other vehicles, how they were parked that day?
Officer, do you have a? Okay.
Could have written that other citation. I don't know.
Okay. So
We're
all the photographs you've presented this morning are all the photographs you took.
Of this
Yeah,
particular situation.
for this case.
That's correct.
Okay. Any other questions, sir?
Were any other citations issued for other vehicles parked similarly to mine that day?
Go ahead.
Very busy time of the year. It's the middle of the summer, so there's very likely a chance that I wrote other citations that day to other vehicles for.
All right. Any other questions?
Not at this time.
Okay. Yeah, because I do see other, vehicles in the background or some other low-speed vehicles, but I can't tell if any citations were written. But all right. So, Mr. Wagner, you can go ahead and present any testimony you wish to present this morning.
Thank you for your time. I'm here regarding the citation I received for parking my LSV across 2 spaces. I wanted to start by saying I take full responsibility for this. I understand that the purpose of parking regulations and regret not parking within a single space in my attempt to maximize parking for everyone. I'm a homeowner in this community, and I take pride in being a responsible member of this community. When I became a homeowner and purchased a LSV, I attempted to thoroughly research the applicable laws and rules for operating an LSV within this county. I regularly research what I must know. However, I failed to locate the citation that I've specifically been in violation of for today. An example of my research has included thoroughly reviewing the low-speed vehicle laws detailed on the Walton County Sheriff's Office website. And unfortunately, I only noted one parking reference, nothing to the point of occupying 2 spaces, and specifically that reference saying parking an LSV directly behind another vehicle within a designated parking space is prohibited. But again, nothing about occupying 2 spaces. I respectfully ask the court for leniency or, if appropriate, dismissal of the citation. This is my first citation. I have taken steps such as researching Walton County's parking and traffic enforcement code. I have subsequently found Section 2026B detailing my violation. Additionally, according to the County Compliance Department's webpage, it's their goal to educate and obtain voluntary compliance, and I ask that the court consider me being here, my time away from work, my time that it took me to attend this hearing, is my willingness to comply with the county's parking regulations and rules that it follows. I apologize, I did not print off. However, I do have photos of myself on the date of the infraction, as well as others parked in a similar manner. My intention is not to excuse my error, but to show that I parked in a manner consistent with others, and I did my utmost to not obstruct traffic, pedestrian paths, or other vehicles. Thank you for your time.
All right, thank you, sir. Did you have something I saw you were reading from something. Did you have something you want to put into the record, or you just wanted to read that?
That's what I wanted to read.
Okay, that's fine.
If that's okay.
No, that's perfectly fine. All right. Do you have any questions for Mr. Wagner? All right, thank you, sir. Mr. Wagner, you can grab a seat unless you have anything else. All right, thank you, sir. All right, at this time, I'll close the evidence portion. And Mr. Wagner, I appreciate you taking the time to come in this morning. Many people don't. We had a couple that didn't, but based on your testimony and the evidence presented and the testimony from the officer, I think it's clear there was a violation. The I do find that, there is a violation of County Code 20-26. I will, at this point, I'm gonna put the order, there it is. Find that there's sufficient evidence to show that infraction occurred and a violation, as I stated earlier, of County Code 20-26 parking. I will provide a reduction in the fine from $100 to $75. I know that may not seem like a lot, but again, I don't think I can in good conscience go ahead and just waive the entire thing. But there is a $50 administrative fee that the clerk's office charges. I cannot and won't reduce that, and the clerk's processing fee of $25. So the total will be $150, and you'll have 30 days to pay that. Is that going to be a problem to pay that in 30 days? All right. Again, Mr. Wagner, I appreciate your time. I understand these mistakes happen, but I hope you understand that I also have to follow what's in the code. And thank you, sir. All right. The clerk will hand you a copy of this, the order, so if you want to try to pay that today, otherwise you have 30 days to pay. All right. Am I correct that we don't have any other?
No.
All right. All right. Based on that and being done with the docket, we are adjourned. You are dismissed. Thank you, sir. Good morning. My name's Hayward Dykes. I'm the special magistrate. We'll be hearing the matters this morning. I'll call to order the November 12th, 2025 code compliance hearing meeting. At this time, if you have a cell phone, please either turn it off or put it on vibrate. We will go ahead and stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. As a reminder, we do record these, so anytime you wish to speak or present testimony, please make sure you come up to one of the podium and speak into the microphones. I've signed the minutes already. Are there any announcements to be made regarding the agenda? Is there any changes or no? Nobody's standing up. Nothing got dropped off. All right. Oh, I've got on the agenda that's before me, I've got 14 active cases, and then I've got 15 through 25 orders to be signed. But are there any cases that either were added or dropped off? We good? Are we missing one, or we got one that coming off? Okay, we'll just deal with it when we get there. All right. All right, at this time, I'll go ahead and swear everybody in at one time. So if you plan to speak today, present evidence or testimony, if you'll please stand and raise your right hand. All right. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? I do. All right. And if anybody missed, you didn't think you were going to speak, and then you decide you want to speak, just let me know when you come to the podium, and we'll swear you in at that time. All right, at this time, our first case on the docket is CE 18-1366. The property owner is listed as Abraham Hasan. The address is 12 Grand Pointe Drive, South, Inlet Beach, Florida. And this is before us this morning for a fine reduction?
Yes, sir.
All right. All right, what I need to consider for this fine reduction? Let me find it first. Yeah. All right, whenever you're ready. Yeah.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regards to case number 18-001366. My supervisor, Georgina Hicks, was supposed to present this case today, but she is out due to a sickness. The property is located at 12 Grand Pointe South, Inlet Beach, Florida. Parcel number 36-3 South 1816180-000-0190. Property owner is Abraham Hasan. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and of county ordinances. The violations cited are 11.04.02A building permits. This case was heard before the Code Enforcement Board on July 19th of 2018, where the property was found in violation. The property owner was given until August 19th of 2018 to come into compliance, or a $250 per day fine would be imposed. A affidavit of noncompliance was completed on August 19th of 2018, and the property owner was able to gain compliance on March 18th of 2019. And the orders have been submitted to you for review.
Okay. I do have a copy of the previously entered findings of fact, conclusions of law, and order issued by the Code Enforcement Board on this matter back in 2018, and the affidavit of noncompliance that was filed in the public record, and then the affidavit of compliance showing that everything had been complied we have that being brought into compliance on March 18th, 2019. So we have 211 days of fine accrual at $250 per day. Based on the calculations provided by county staff, that puts the amount of fines that have accumulated as $52,750. And then county's recommendation is to reduce the fine by 50%.
Yes,
That
sir.
would reduce it to $26,375. There's an admin fee of $23, so a total of $26,398 is what the county is requesting. Let me look at this fast. So this was failure to obtain building permit?
Correct, yes, sir.
And is there some reason this wasn't brought, I mean, seems like 6 years, give or take, from whenever the property was brought into compliance? Why it wasn't?
From what I understand, the property owner wasn't aware of the fines that were that had accrued,
Okay.
was what my supervisor had informed me of. Is that correct, Mr. Hasan?
Yes, I was not aware. I thought everything was done.
Well, it looks like everything was done, but there was a period of time where it wasn't, and that's when the fines accumulated. So that's what we're dealing with today. So I was just curious as to why maybe the fine reduction wasn't addressed in either 2019, 2020. That's fine. We'll deal with it today. That was just a question I had on timing.
There was a lot of miscommunication going on. I mean, the project was done within like 4 weeks. I was just dealing with the engineer. The engineer would just send in work that the county didn't like. So I kept going back and getting paid and charged for it. Eventually, he sent the right stuff, and that's when it ended. But really, the project was way done, and there was no harm to nobody. Neighbors, nobody was disturbed. It was just putting a roof on a balcony.
Understood. Okay. All right. So you've heard what the county's requesting as far as your request for fine reduction. Well, what evidence do you want me to consider, and what would you ask for this morning as far as a fine
I'm asking
reduction?
for a waiver or reduction of fine, or a lot less than than half. Half is just it's still too high. That's just a
Understood.
great hardship.
Okay. Well, what do you propose?
I'll say $5,000.
Okay.
I don't mind. I feel like I called initially and they told me, oh, that's a small project, do it, it's okay. But as soon as the subdivision was being built at that time, and the code man was there every day. So eventually he asked us, do you have a permit? I said, they told us no. He said, yes, you do. I came in that day and applied. Somehow it looked like I applied twice. That's a mistake. I don't understand.
Okay. Well, I don't doubt there might have been some communication or a mistake. And it happens still today. And I mean, there's a lot of things going on. So, Mr. Hasan, your request is instead of the 50% reduction, to reduce it to 5,000, which I guess based on my crude calculations would be about a 10%.
Mm-hmm.
Okay. All right. Does the county have any comments regarding Mr. Hasan's request? All right. All right. Anything else from either the county or Mr. Hasan?
No, I'm good.
All right. Thank you, sir. You can grab a seat. I'll go ahead and close the evidence portion of this hearing. Based on the testimony and evidence presented, I do find that there is sufficient evidence to support a fine reduction. I think that the county's request is in line with what they normally provide for in these situations. However, I do find that Mr. Hasan's 10% request would be sufficient, considering the violation that occurred and the time that elapsed. So based on that, I will reduce the fine to $5,000. Mr. Hasan, be aware that if you'll have 30 days to pay that reduced fine amount. If you don't pay that reduced fine amount within 30 days, then automatically the full fine amount that has previously accrued will go back into effect. So do be aware that you need to pay this timely, because if not, then the full amount will go back into effect. Do you understand that, sir? Okay. There is a $23 administrative fee that you'll also have to pay, so it'll be a little bit more than the $5,000 that you requested. And I just messed up this order. I signed in the wrong place, so we'll need a new order. So somebody will need to get me a new order. But how long before Mr. Hasan can go pay that? All right. That's fine. I mean, you can. Yeah, I think they've got it to where you can pay that at the office now instead of having to go to the clerk's office. So anyway, I messed up. I signed in the wrong place where the code enforcement clerk was supposed to sign. But again, $5,000, 30 days from the date the order is signed. You also have the $23 administrative fee, so don't forget about that. All right. Do you have any questions, Mr. Hasan? All right. That concludes your case, and you're free to go, sir, if you'd like.
May I approach?
Yes. Yeah, if you want to go ahead and put the amounts and everything in, that'll be fine too. All right. Our next case is CE 25-01-889. Property owner is listed as Pamela Bieda, B-I-E-D-A. The address is 316 East Royal Palm Avenue in DeFuniak Springs. And this is also here this morning for a requested fine reduction. All right. Is the property owner here Pamela Bieda? Do I have her stuff up here?
Yes, sir.
Oh, got it. All right, whenever you're ready.
For the record, it's Officer Harold Serrano with Walton County Code Compliance, submitting the final summary case report as testimony in regards to case 25-01889. To the case, this was a similar case, and citizens served with case number 21-001983. Parcel is 16-3 North 20-20-060-045-0030. Property located at 316 East Royal Palm Avenue, DeFuniak Springs, Florida. Violations are cited as 1.13.09 building permit and 7.02.01 junk and litter. History in this case is heard before you on 6/16/2021, where the property was fined in violation. Property owner was given until 6/28/2021 to come into compliance for a $50 per day fine to be imposed. A affidavit of noncompliance was completed on 7/2/2021. Property owner was able to obtain compliance on 11/4/2025. This case I was not originally assigned to. This was a case before me. Reading notes, the defendant was not aware of the accruing fines. Before I could even make a violation out, she had actually called up because she was apparently trying to sell the property and was notified about the occurring fines. On my end of it being a new officer appointed to this case, the defendant was very in a hurry, eager to get it complied. So she was in compliance within 2 days of realizing that there was still some more junk and debris from previous notes from 2021. The reduction fine total was $79,500. Normal request is 25%, totaling $19,875. In my opinion, since she was so eager to get that done, and before I could make a violation, even ordered to her, she was in compliance. So I was going to recommend to the court, if she was here today, at a 1% from the $79,500 would be a total of $818, including the administration fees.
Okay. Do we know why she's not here today?
I am not aware. I made contact with her via phone last week, and she had told me that she was going to make sure she was here, and was eager that we expedited this for her because she seemed to be trying to close on a sale on this property.
All right, thank you, sir. I didn't see anybody come in, so I'm assuming she's not here. There's no representatives here for Pamela Bieda.
And as a just sorry to interrupt,
Go ahead.
but I also looked at the notes from the prior magistrate notes as well, and she did not make a notice to appear as well as on that one either. So that's why I gave her a little bit, because she seemed to not know that there was a violation of it and occurring fine. So I gave her the benefit of the doubt on that, being the new officer on the case. As of today, I can speak on my experience that she was knowledgeable about the hearing today.
All right, thank you, sir.
Thank
All
you.
right, I'll go ahead and close the evidence portion. Based on the testimony and evidence, I do find that a fine reduction would be appropriate. I don't know that I'd necessarily like that Miss, probably pronouncing this wrong, Bieda, had requested the fine reduction but didn't take the time to show up, especially since she wanted to expedite things because she's in the process of selling her property. So, and I do appreciate the county, looking to reduce the fine to what I would consider a very reasonable amount, considering the violation had accumulated for over 1,000 days, or 1,590 days to be exact. So while I appreciate the county's reduction, and I will, this wouldn't even be splitting the baby per se, but I'm going to go ahead and reduce the fine to $1,500. And I think you can present to Ms. Bieda, if you speak to her, that she likely would have got a lower amount had she appeared. But I believe based on the amounts of time that the property was out of compliance, warrants a little bit higher fine than 1%. So $1,500, she'll need to pay that within 30 days. So if you speak to her, do advise her that she has 30 days to get that paid. Otherwise, the amount will go back to the full amount that was previously in place, which was $79,500. Also advise her that she has a $23 administrative fee that will also need to be paid in addition to the $1,500. All right, and I've signed that order. All right, our next case is CESTR 250169. Property owner listed as Shawn and Sherri Schmonsky. All right, am I saying that right? Schmonsky. All right. And the property address is 455 Hidden Lakeway in Santa Rosa Beach, Florida. And this is also before us this morning for a fine reduction.
Good morning. For the record, I'm Code Compliance Officer Andrew Underwood with Walton County. I'm presenting case number CESTR-25-00169. Owner Shawn and Sherri Schmonsky is up for the property located at 455 Hidden Lakeway, Santa Rosa Beach, Florida. Parcel ID 02-3 South-20-34300-000-0740. This case was presented at the magistrate hearing on September 23rd, 2025. The property was found to be in violation of Land Development Code 1.13.16A, short-term vacation rental certificate required. It was ordered that the property gain compliance on or before September 25th, 2025, at which point a $500 per day fine shall accrue. The property gained compliance on October 7th, 2025. This equated to 12 days of non-compliance, resulting in a $6,000 fine. In your packet, you will find an order of fine reduction, as well as copies of the final order, order of imposing fine, an affidavit of non-compliance, an affidavit of compliance, and a receipt showing that the administrative fees from the original hearing are paid in full. Administrative fees for the costs incurred with this fine reduction hearing shall be $23. It is the county's observation that this property is income producing and not a homestead. Also, no errors were made on behalf of the county in prosecuting this case. Therefore, at this time, the county recommends no fine reductions.
Okay. All right, Miss, are you Sherri Schmonsky?
I am, yes.
Okay, good morning, ma'am.
Good morning.
You've heard the county's position. Obviously, the property's been brought into compliance based on the county's testimony. We're here on a fine reduction. What would you like for me to consider this morning?
Just the fact that I guess all the documentation was mailed to the property address and that we never received any of it. Therefore, we didn't realize it wasn't in compliance. The only reason I found out it was in compliance was because one of our team members stopped by the house on October 2nd and saw a notice of hearing that I was supposed to be there on 9/23. This was October 2nd. As soon as I heard about it, I jumped into action to figure out what was going on, to try to rectify the situation. And within 2.5 business days, I had everything taken care of and moving forward to get it in compliance.
Okay, remind me, what was the violation? Was it not registering with the county, not registering with the state, or?
So I believe in order to be registered with the county, they have to be registered with the state. So I don't have clarity. I can call Mr. Allen to the stand. He
Yeah,
can
I'm just
corroborate that
curious as
information.
to, there's like 3 or 4 boxes they were supposed to check. How many of the boxes did you need to check?
Yeah, good morning, sir. At the time that the case was presented to you, the property was not registered with TDT and it was not licensed at
Right, with the
DBPR.
county.
Correct. It
Oh,
came
with DBPR, okay,
Yeah.
so none of them, all right.
Yeah. And for the record, pursuant to Chapter 7, all notices are sent to the address on file with the tax collector and property appraisers, which in this case, was the property itself at that time.
You're right, yeah, and that's usually something we look at is whether or not the notices were sent to the, what's listed on the tax rolls, so,
Correct.
if
And,
that was,
yeah,
okay.
we later found out that, and it looks like, according to this, is it still not correct on the, it still has our mailing address even, I thought I called the appraiser's office. I don't know if it takes time to, be of record or not, or if I need to call them again and have the mailing address corrected.
Yeah, I don't know the answer to
Okay.
that. I don't know if it,
Okay,
I mean, I would assume there's some lag, but I don't know how much, or
Okay.
if.
okay,
it
I'll
was
call
that.
and double check just to make sure that none of,
Well,
nothing like this happens again.
Yeah, yes, ma'am. And Ms. Schmonsky, okay, so you've heard that the county is, they're not recommending any fine reduction. What are you requesting this morning?
I'm requesting a reduction just in the fact that as soon as I found out about it, in 2.5 business days, I had it taken care of. Had I known about it before, I definitely would have, but I thought everything was in compliance back in 2023. I mailed in everything, not knowing that there was an online, thinking that I was just waiting on the county to get back with me, and clearly that's not. And if they were, apparently, they could have been mailing to the property address, and I didn't realize that they didn't have our home address in Tennessee.
Okay. So, again, am I to take that as you're asking that it be zeroed out completely, or is there some amount that?
I mean, I'm willing to
pay.
pay some amount if that's what the county would, agree to, yes.
Well, the county's saying they want 6,000. I'm asking you this morning, you're asking for a fine reduction. What are you requesting from me? Is it 0 or is it some other amount?
I would request 0.
Okay. All right. Anything from the county regarding Ms. Schmonsky's request?
No, sir.
Okay. All right. Thank you both. At this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact, that the property listed at 455 Hidden Lake Way has, based on the county's testimony and evidence presented, is now in compliance, that the accumulated fine for 12 days for being in violation was $6,000, that the county has requested that that fine not be reduced, and Ms. Schmonsky, on behalf, as a property owner, has asked that to be reduced to $0. I'm not going to honor either person's request or either party's request. I'm not going to order $6,000 as the accumulated fine or the $0, but what I will do is, based on the fact that it was brought into compliance within 12 days, apparently based on the county's testimony and Ms. Schmonsky testifying that it was brought into compliance within approximately 3 days, what I will do is order a $600 fine as well as $23 in administrative fees for today's hearing. Ms. Schmonsky, you'll need to have that paid within the next 30 days. Otherwise, the fine will go back up to the original amount of $6,000. Do you understand that? All right, and I've signed that order. You can pay that through the, I think they pay that through the code compliance, and he'll get with you. Okay. So as stated earlier, $600, $23 administrative fee. All right. Any questions? All right. Thank you both. Our next case is CE 25-01346. Property owner is listed as Deborah Christopher, and the property address is 417 North County Highway 393, Santa Rosa Beach, Florida. And this is not a fine reduction. So do we have anybody here for the property owner, Deborah Christopher? All right, I don't see anybody standing.
Sorry, I think on the agenda number 4, another fine reduction.
Oh, wait. Oh, mine, yeah. My agenda jumps from 3 to 10, so I shouldn't have even called Miss Christopher. Let me, do you have a, Gina, you got another agenda? This one jumps from 3 to 10, so I'm missing the other. All of them do? Okay. Well, hold on a second, I can pull it out. Okay. Yeah, I just need, yeah, probably just those. All right, sorry about that. So actually, number 4 on our agenda is a fine reduction. It's property owners Michael and Barbara Galvin, Galvin. The address is 22 Shella Street, Shella Street, Santa Rosa Beach, Florida, and this is listed as a fine reduction. All right. And are you Mr. Galvin?
Yes, I am.
Okay, good morning, sir. All right, whenever you're ready.
Yes, sir. For the record, I'm Walton County Code Compliance Officer Andrew Underwood. I'm presenting the case CESTR-25-00173. The property owner, Michael and Delphia Galvin. The property is located at 22 Shella Street, Santa Rosa Beach, Florida. Parcel ID 01-3 South-20-34501-00B-0060. This case was presented at the magistrate hearing on September 23rd, 2025. The property was found to be in violation of Land Development Code 1.13.16A, short-term vacation rental certificate required. It was ordered that the property gain compliance on or before September 25th, 2025, at which point a $500 per day fine shall accrue. The property gain compliance on October 8th, 2025. This equates to 13 days of non-compliance, resulting in a $6,500 fine. In your packet, you will find an order of fine reduction, as well as copies of the final order, order of imposing fine, an affidavit of noncompliance, an affidavit of compliance, and a receipt showing that administrative fees for the original hearing have been paid in full. Administrative fees for the costs incurred with this fine reduction hearing shall be $23. It is the county's observation that this property is income producing and not a homestead. Also, no errors were made on behalf of the county in prosecuting this case. Therefore, at this time, the county recommends no fine reduction.
All right, thank you, sir. All right, Mr. Galvin, you were sworn in earlier?
Yes, I was.
Okay, thank you, sir. You've heard the county's position. They're opposed to any fine reduction this morning. 13 days, they claim, before the property was brought into compliance, and $6,500 in accumulated fines. What are you requesting this morning in regards to the fine reduction?
I'm requesting a waiver of the fines based upon a number of factors. Number one, I did not receive any notice at any address. I checked my mail last night, I had the mail out in my car. There was no county documentation stating about this new requirement, nor was one sent to my home address in Diamond Head, Mississippi. You know, the county might have used emails and other forms of communication, a new requirement, which I was unaware of, and that has not been done. The first notice that I observed of this is when my housekeeper went by to get the house ready for my daughter, who was going to use the house, and called me and said, you know, there was a notice on your door. I said, no. I said, my house is fully compliant. I have filled out all the state forms. I filed my taxes, everything in a timely manner. I said, I don't know anything about a county requirement. And even on our owner's website, 30A, there's very little chatter about this other than how do you get your railings and balconies inspected, which I had done religiously. And mine were always in compliance, and I'm in compliance with the state. So I feel that there was a lack of communication. How that happened, I cannot explain. But I did not receive notice at any address, and that at this time I would request that I be given a prayer for judgment and that these fines be waived.
All right. Any comments from the county regarding the claims for lack of notice or proper notice in this matter?
Just that all forms of mailings for the notice of hearing in violation were sent pursuant to Florida Statute 162 at least 30 days prior, and then the property was posted publicly at the courthouse and on the property location itself, also pursuant to Florida Statute 162. So all boxes were checked on the county's end there.
And what does the county have or understand the address to be for this property related to notice requirements?
I'll have to call Mr. Josh Allen to the stand to answer that question.
Allen?
Good morning, sir. Yes, at the time of the case being presented to you, the property was listed as mailing address of the property itself. And that's probably why the certified mail was not received, because no one was there to receive it. But I will agree that Mr. Galvin was licensed at the time and also registered and in good standing with the TDT.
So what was the deficiency then for the original?
Not registered with the county, sir.
So otherwise just getting the registration with the county, correct?
Yes, sir.
And Mr. Galvin, have you always had, or is it your claim that you've always had the property listed as the Mississippi address?
Yes, I did. Thanks to the help of our code compliance officer, we did root out the error was when I was registering with the state, a lot of people got involved, I guess, and that somehow my address was changed from 755 Cherry Hill Drive to 22 Shella Street. But as I pointed out, there is no mail was received. I did not leave anything in the mailbox. And I used, in my past life, I had a job that when we sent notice, if the notice was not received, we had other steps we had to take to ensure that an individual was aware that an action was taking place and that there was a requirement. And in this case, I believe additional steps should have been taken to notify me that an action was required.
Understood. And while I can understand, I mean, it looks like, at least on the tax rolls and tax collector's website, that it has the this address listed. So if that was and I guess what I'm saying is I don't find that the county had made a mistake, because, you know, at least here in Florida, the laws only require that they look and find out what address is listed on the tax rolls, and that's
Right.
where they provide the notice to. So, while I understand, you know, yeah, they could do more, the law doesn't require them to do more, and they're not, I mean, generally, they're probably not gonna do more just because the cost and the time related to something like that. So,
But I would
understood.
point out, sir, that I did not receive any notice at my 22 Shelley address either.
Okay. And what's the county say to that? Was
I
that
would,
posted?
I would
or-
like to clarify that was posted at the property. I believe that's how they made the discovery that it was non-compliant, because of the physical posting at the property.
All right. So yeah, they can either mail it, or they can post it. And in this case, the county's saying they posted the property, is correct?
Yes, sir. More than 10 days prior to the hearing date.
All right. All right. Anything else, Mr. Galvin?
No, I think posted it on the door of a vacant house, though. Normally my neighbors would have seen it. My neighbors take my mail and everything else. So again, it was a disappointment. I think there's many factors, but I am always in compliance. I've been very straightforward with that and been very aggressive in following the rules and regulations for short-term rentals. But this is a past in the night where things have happened.
Understood. No, I mean, I don't hear or see any evidence that would suggest that this was on purpose, or, you know, anything more than maybe at best some type of oversight, as far as registering with the county. So, all right. Well, thank you both, gentlemen. I'll go ahead and close the evidence portion. I'll accept into evidence the testimony and evidence presented and make the following findings of fact. I'll find that based on the county's testimony and evidence presented this morning, there is sufficient evidence to find that the property located at 22 Shella Street, Santa Rosa Beach, Florida, while previously in violation of Walton County Code, was brought into compliance. That based on the county's request that there be no fine reduction, I'm not going to honor that request, but I'm also not going to honor Mr. Galvin's request to make it 0. But what I will do, Mr. Galvin, is reduce the fine in this matter to $65 or $650, basically $1 or $100 per day that the property was. Well, that's not $100 a day. Let me see. We're not going to do $100 a day. We're doing $650 with a $23 administrative fee. So $650 will be the fine reduction. You'll have 30 days to pay that, Mr. Galvin. If you don't, or if you fail to pay that within the time provided, that amount will go back up. So please take the necessary steps to make sure that's paid timely. There's the $23 administrative fee, and I'm signing that order right now. And you can get with county staff on how and when to pay it. All right. I appreciate you coming out today, Mr. Galvin, and you're dismissed. All right. And there's the order. All right. Our next case is case 24-00-993, and the property owners are listed as Kenneth and Melba Boyd. And this is also a fine reduction. This is related to the property at 180 East Wilson Street in Santa Rosa Beach, Florida.
I guess due to the missing page, it was not, that's the one that I was referring to this morning.
Oh, okay.
As the one that would need to be removed off the agenda.
Is that going to be reset, or we're just taking it off? at this
It's
point?
gonna be reset, yes, sir.
Okay, that's fine. So, we'll skip that one. Our next case is case number CE 25-01401. Property owner listed as Jerry Wallace, and this is, location or address is 1164 Indian Woman Road in Santa Rosa Beach, Florida. Do we have Mr. Wallace here, or somebody for Mr. Wallace? All right, I don't see anybody standing. All right. Whenever you're ready.
I am Officer Uriel Baza with Walton County Code of Compliance. For the record, I am submitting my final summary case report and testimony regarding case number CE 25-01401. This property is located at 1164 Indian Woman Road, Santa Rosa Beach, Florida 32459. Parcel number is 14-2S or 2 South -20-33-000-007-0010. The violations cited are 1.13.00 A, development approvals, 1.13.09 C, building permit, and 2.02.00 P, RVs and campers. A complaint came in for living in RVs, trailers, and sheds. I conducted my initial inspection at the property on May 1st, 2025, where I observed 2 RVs in the front yard appearing to be used as a living dwelling, and also with several structures in the backyard. After conducting research and reaching out to our planning and building departments, I was informed that no permits for these structures were found on record. On May 14th, 2025, a notice of violation with the corrective actions required was posted at the property. On July 21st, 2025, I received a letter from the property owner stating that he does not consent of the violation cited. Other than that, I have not been in contact after attempting phone calls to numbers found on public search sites. After conducting several follow-ups, it was noted that 1 RV was removed from the property. Status checks for application submittals showed no activity through the county portal. Notice of hearing was sent certified mail and posted at the property on October 12th and the 13th. It was also posted at the South Walton Courthouse on October 22nd, 2025. As of today, the property is not in compliance with the violation cited. Photos in your packet show the initial inspection and the pre-hearing inspection conditions with the violations still existing. I would like to submit my packet into evidence.
All right, that'll be accepted. The, now on the initial, activity report, there was a violation code listed for exterior storage, not operating vehicles, junk or debris, 5.07.09 C, but I don't see that as being an item that's gonna be addressed this morning. That's
No.
been resolved?
Yeah, it's been resolved.
Okay.
Well, I think when I initially went out there, the properties, they appeared to be, there were 2 separate parcels that appeared to be one, and the other property kind of got mixed in there, and I put the junk and debris or the dilapidated vehicles because that one did have several vehicles in there.
Okay, so I just want to be clear that what we're dealing with though today is only going to deal with the items that you have listed on the draft order, 1.13.0 development approvals, 1.13.09 building permit, and 2.02.00 P RVs and campers, right?
That's right.
Okay, so I'm not going to make any findings related to anything beyond those 3 this morning.
Mm-hmm.
All right, anything additional that, what's the county's recommendation regarding,
Our recommendation is 33 days to come into compliance, which would date us to December 15th. or a $200 per day fine to accrue. And there's also a $73 administrative fee.
All right, thank you, sir. All right, I saw somebody walk in. That's not Mr. Wallace, was it? All right. All right, thank you, sir. I'll close the evidence portion. I'll accept into evidence the county's packet. Make the following findings of fact and conclusions of law. Find that the property listed at 1164 Indian Woman Road, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is a violation of 1.13.00A, 1.13.09C, as well as 2.02.00P as in Peter. I did see I guess it's an unsigned letter that was presented from the owner. I did take that into consideration, but still find that there's a violation. As stated previously, based on the county's request, we'll provide that the property must be brought into compliance on or before December 15th. In the event the property is not brought into compliance on or before December 15th, a $200 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee that will need to be paid regardless of whether or not the property is brought into compliance. And that administrative fee will need to be paid within the next 30 days. All right, did I miss anything?
No, sir.
All right, sign that order, and that'll conclude that case. Next case is 25-01453. Property owner is listed as, I'm probably gonna mess this up. I'll just say Susanna Hernandez. It's, the address is West Cypress Avenue in DeFuniak Springs, Florida. Is this a undeveloped lot, or?
It is.
Okay, so it's an undeveloped lot, parcel number 16-3N20-28-060-022-0180. Have you had any contact with the owner?
I have not.
Okay. Anybody here on behalf of, I'll try to say it, Huete, Huete, Mailey, Maely, Susanna Hernandez. Okay, I don't see anybody standing up. All right, Officer Beza, whenever you're ready.
Again, Officer Uriel Baza with Walton County Code of Compliance. For the record, I am submitting my final summary case report and testimony regarding case number CE 25-01136. This property is located at West Cypress Avenue, DeFuniak Springs, Florida 32433. Property owner is listed as Mayley Susanna Hernandez Huete and Manuel de Jesus Pereira Hernandez. Parcel number is 16-3 North-20-28060-022-0180. This property is in the unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 in the county ordinances. Violations cited are 1.13.00 in development approvals, 1.13.09C building permit, 1.13.09F clearing permit, and 5.07.09C exterior storage of non-operating vehicles, junk, or debris. I got a complaint come in for junk and debris and setting up a trailer with no permits. I conducted my initial inspection at the property on May 21st, 2025, where I observed a dilapidated mobile home on a property with several items laying around. After further research, I found that the property does not have the necessary permits for clearing or for the mobile home. I was able to speak to a neighbor who approached me, who provided a good phone number for the property owner. I called the number and left a voicemail for a callback. I have not received a callback, and I have not made contact any other way with the property owner. Notice of violation and stop work order was posted at the property on June 4th, 2025. Notice of violation was also sent certified mail to the address listed on the property appraisal site on the same day. Several phone calls have been made to make contact, but have not been successful in contacting the homeowners. On October 12th, 2025, notice of hearing was sent certified mail and posted at the property. On October 21st, 2025, the notice of hearing was posted at the South Walton Courthouse. As of today, the property is not in compliance with the violations cited. Photos in your package show the initial inspection and the pre-hearing inspection conditions, with the violations still existing. I would like to submit my packet into evidence.
That'll be accepted. What's the county's recommendation?
Recommendations is 33 days, December 15, 2025, to come into compliance, or $200 per day, per day fine to accrue. And then the $73 administrative fee.
Thank you, sir. All right, I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented, the county has provided sufficient evidence to show there's a violation at the property located on West Cypress Avenue in Phoenix Springs, Florida, parcel ID number 163N20280600220180. The violations that have been proven this morning are a violation of 1.13.00A, development approvals, 1.13.09C, building permit requirement, 1.13.09F, clearing permit, and 5.07.09C, exterior storage of non-operating vehicles, junk or debris. Based on the county's recommendation, I'll provide that the property must be brought into compliance on or before December 15th. In the event the property is not brought into compliance by that date, a $200 per day fine will be imposed. In addition to the fine, there is a $73 administrative fee. That fee will need to be paid regardless of whether or not the property is brought into compliance, and the property owner will have 30 days to pay that administrative fee. All right.
Thank you.
Thank you. Our next case is CE 2501434. Property owners list as Permentier Holdings LLC. And I also have a Wayne Lawler listed. That address is 255 East White Rose Street in DeFuniak Springs, Florida. Are you Mr. Lawler? Okay. Yeah, Mr. Lawler, if you want to go ahead and grab a seat right there, we'll let the county present. Then you can ask any questions of the officer. And then after that, I'll let you testify and present any evidence you wish. All right? Thank you, sir. All right. Let me find this one. You know where you put this one at?
Yeah, it should be right up.
Yeah. Well, it probably is. I might just be overlooking.
I think it's one on the bottom. Actually, I think it's both of them in a row.
Okay. All right. Go ahead.
For the record, I'm Code Compliance Officer Darnell Bennett. I am submitting my final summary report, presentation, and testimony in reference to case number CE-25-01434. The property is 255 East White Rose Street, DeFuniak Springs, Florida, 32433. Parcel number is 17-3 North-20 280-085-0080. This property is in an unincorporated area of Walton County and therefore subject to the Land Development Code, Chapter 7, and county ordinances. Property owner is listed as Permitter Holdings LLC or Mr. Wayne G. Lawler. The violations cited were 1.1300A development approvals, 1.1309C building permits, 5.0709C junk and debris. The initial complaint was from a walk-in complaint for junk and debris and someone possibly living in a RV/camper. An initial inspection was conducted on May 13th, 2025, where, while speaking to the person living in the RV, I observed that there were multiple violations on the property, as listed before. I was able to then speak with the property owner, Mr. Lawler, who explained that on May 21st, I was able to speak with property owner, Mr. Lawler, who explained that he wasn't aware that there was a person living on the property in the RV and that he had him removed, thus resolving the violation of 2.0200P. He also mentioned that he had been slowly attempting to remove all the junk and debris that was on the property. Notice of violation was posted to the property on May 16th, 2025, and certified mailed on May 23rd, 2025, with follow-up inspections on May 30th, June 5th, July 8th, July 17th, and August 4th of 2025. I was able to monitor the progress of the cleanup, but at that time, no submissions to planning had been made. On September 17th, 2025, it was discovered that the original notice of violation had been sent to the wrong property owner due to contact information being incorrect or changed on the county's property appraiser website. With this, on September 17th, a new notice of violation was posted to the property and certified mailed with the correct information. With the corrected information on September 23rd, I was able to speak with Aisha from Kings Lake Realty, otherwise known as Permitter Holdings, LLC, and explain the nature of the complaint, violations, and potential steps to gain compliance. She expressed that she had been in contact with Mr. Lawler and that the proper documents would be submitted to planning, and that information was verified on October 9th, 2025. With this, a notice of hearing was posted to the property and certified mailed on October 17th and posted to the courthouse on October 24th of 2025. As of today, the property owners have all submissions into planning, all documents submitted to planning, and they are currently awaiting a surveyor so they can complete the BPR process with planning and then obtain building permits. With this information, despite all of their efforts, the property does remain in violation. The property owner failed to bring the property into compliance within an allotted time. Proper notice was provided as prescribed by code. And as of my most recent inspection of today of November 12th, 2025, the property remains in non-compliance. I ask that the magistrate find the property to be in violation.
Okay. Thank you, sir. Mr. Lawler, do you have any questions for Mr. Bennett? Mr. Bennett, don't walk off in case he has anything. And I do know, while you were speaking, it does appear that there was a deed recorded in the public record October 15th transferring this property from Permitter Holdings LLC to Mr. Lawler. Does that sound correct, Mr. Lawler?
Yes, sir.
Okay. And your previous conversations with the owner, were those representative from Permitter Holdings, or was that Mr. Lawler, or both?
Initially, before September 23rd, it was with Mr. Lawler. At that time, when I was originally going to send out the notice of hearing, I noticed the change on the property appraiser website. There was a conflict between our system with the county and with code and the property appraiser. So I had to resend out everything. And And then at that point, had contact with Miss Aisha from Permitter Holding.
All right. And Mr. Lawler, you're not are you a owner of Permitter or member of Permitter Holding?
No, sir. I purchased from them.
All right. All right. I just wanted to clear up that little bit of information while you were, well, Officer Bennett was going over. Do you have any questions for Officer Bennett?
No, sir.
Okay. Officer Bennett, you can grab a seat then. Mr. Lawler, what do you want me to consider this morning?
All of this occurred in a state of turmoil for me. I was going through a divorce. My ex-wife had just left me a dear John while I was working and took off with my 3 children halfway across the country. I'm now in a custody battle dealing with that, and all of that chaos having downsized so much, so to speak. I decided to get rid of the 4-bedroom home that me and my ex-wife had previously purchased, and I had bought a small single wide. My intention was to chip away at it and remodel the single wide and eventually put it in its place. At that time, I was not aware, first time homeowner, I wasn't aware that I was in violation. Just to have the trailer on the property. Now, you know, of course I knew I couldn't stay in there. Anyhow, so that trailer is actually no longer there. I've completely demolished it and wasted that entire investment. I'm going through everything I can, jumping one hurdle after the other. I've had 3 surveys done on this property in the last 4 years. And just this morning, I spoke with a man who's out there to put flags on the property for $1,000 for the 4th one. The only thing that I can really request is a extension of sorts. At this point, it's been in the hands of the planning department for about 2 months, give or take. Just waiting on the processes and checking my P's and Q's with them. I want nothing more than to comply and stay out of trouble.
Understood. How much time do you think you would need to get the permits? And is there any more debris or anything that needs to be picked up out there?
As I say, I just finished demolishing that trailer. The only thing from the single wide there is little stuff to pick up off the ground by hand and the floor.
Okay.
I get some axles under it this evening, and I'm going to have it completely out of there.
Okay. All right. Well, that's great to know. What going back to my original question, how long do you think it would take to kind of wrap up? I know you don't have any control of how quickly the county looks at your stuff, but what do you think would be a reasonable amount of time?
I would like to tell you 30 days would be no trouble at all. I've been advised to ask for 90 due to the fact that it is out of my hands.
Okay. All right. Anything else?
No, sir.
All right. I appreciate that. Officer Bennett, you got any questions for Mr. Lawler? I'm sorry.
No, sir.
Okay. Any comments regarding Mr. Lawler's request for a 90-day time period? Any comments on that?
No, sir, not about the time period.
Okay. What's the county recommending or seeking?
Whatever you suggest as far as the time period to bring it into compliance, or $100 per day fine, as well as a administrative fee of $73.
Is it 73 or 84? I've got 84 on this draft.
Oh, yes, you're right. 84. I'm sorry.
All right. Mr. Lawler, it seems like the county doesn't necessarily have a preference on 90 days or less. So you feel 90 days would be sufficient?
More than. Yes,
Okay.
sir.
And then you understand if the property is not brought into compliance within the 90 days, there would be a $100 per day fine that
I
will
do.
accumulate.
You
Okay.
will not see me again.
All right. All right. And then you also understand one last thing, that, you know, when you think you've got everything in compliance, you need to contact code compliance so they can inspect or check to make sure everything's
Right.
done.
We've been in tight communication.
All right. All right. Thank you, sir. If there's nothing else, I'll go ahead and close the evidence portion of this hearing. I'll accept the county's staff report and packet into evidence. and based on the testimony and evidence, I'll make the following findings of fact and conclusions of law. I'll find that the property listed at 255 East White Rose in DeFuniak Springs, Florida, is owned by Mr. Wayne G. Lawler and is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. That the testimony and evidence presented this morning shows that there is a violation at the property, specifically 1.1300A development approvals, 1.13.09C building permit requirements, and 5.07.09C junk and debris. Based on the request by the property owner, Mr. Lawler, I will provide that he needs to bring the property in compliance within 90 days. How long? What date would that be? All right, so you'll have till February 10th of 2026. If the property is not brought into compliance on or before February 10th, 2026, a $100 per day fine will be imposed. In addition to the fine, there's an $84 administrative fee. That'll need to be paid regardless of whether or not the property is brought into compliance, and you'll have 30 days to pay that. You understand that, Mr. Lawler?
Yes, sir. Is that 30 days today or from February?
No, it'll be from today.
Okay.
Okay, so yeah, that'll be paid. If you get the property brought into compliance tomorrow, you still got to pay that admin fee.
Right.
All right.
Right.
All right. Any questions, Mr. Lawler?
No.
All right. Best of luck to you, sir. Thank you for showing
Thank
up.
you very much.
All right. Our next case is CE 25-01346, and that property owner is listed as Deborah Christopher, and the address is 417 North County Highway 393, Santa Rosa Beach, Florida. Is Miss Christopher here, or a representative for Miss Christopher? Okay, I don't see anybody standing. Officer Bennett, whenever you're ready.
For the record, I'm Code Compliance Officer Darnell Bennett. I am submitting my final summary report, presentation, and testimony in reference to case number CE-25-01346. Property is 417 North County Highway 393, Santa Rosa Beach, Florida, 32459. Parcel number is 27-2 South-20-33 500-000-020. This property is in an unincorporated area of Walton County and therefore subject to Land Development Code Chapter 7 and county ordinances. Property owner is listed as Deborah Christopher. The violation cited is 7.02.01, junk and litter. The initial complaint was via email about junk and debris. An initial inspection was conducted on April 4th, 2025, where I observed that there were violations of junk and litter. A follow-up inspection was conducted on April 8th, at which time I posted a notice of violation to the property, and that was certified mailed on April 11th, 2025. On April 22nd, 2025, an updated notice of violation was posted and certified mail with the additional violation of 1.1309C building permits. That was later resolved on May 7th, 2025. After this, on May 13th, 2025, contact was made by the tenant, Miss Ashton, who visited the code office to sign a right of entry form so that the landfill could drop a county dumpster to assist with the cleanup of the junk and litter. This dumpster, however, was not placed on the property until somewhere between my follow-up inspections of July 8th, 2025 and July 17th, 2025. With follow-up inspections on July 22nd, August 5th, August 15th, September 9th, September 16th, and October 8th, 2025, I was able to monitor the progress of the cleanup. However, on October 14th, 2025, a notice of hearing was posted to the property and certified mailed on October 15th, 2025. On October 24th, 2025, the notice of hearing was posted to the courthouse. And on October 28th, 2025, I spoke with Mr. Fred from the landfill and requested that the dumpster be removed from the property due to lack of progress being made. As of today, November 12th, 2025, despite the initial efforts, this property remains in violation of 7.02.01 junk and litter. The property owner failed to bring the property into compliance within the allotted time. Proper notice was given as prescribed by code. I ask that the magistrate find this property to be in violation.
And you want to introduce your report and pack it in the evidence?
Yes, sir. Yes, sir.
I'll accept that. I think the last photograph that I have, the pre-hearing photograph, 11/12/2025. So that dumpster is not the county's dumpster? I see a dumpster in the...
Yeah, that's still the county's dumpster. They hadn't picked it up yet.
Okay.
Yes, sir.
But it looks like there was a shed or a tiny home that was demolished and taken out, but we're still dealing with some other...
Yes, sir. Yeah, I tried to get the photos to really show it, but around the camper, there's a lot of junk and litter still. That little tiny blue home is not permitted to be there, and it's on like a broken down trailer type axle thing. From the initial photo, that tan one or the brown one, it's in the same condition. It's just behind the truck, so it's...
Oh, I thought that was the one that got broke down. Okay, well,
Yeah, they're both in the same
have you
condition.
had contact with the property owner and advised them on what additional things, or maybe the tenant that?
Yes,
they
I spoke with the tenant
things
quite a
under
bit
control?
throughout the process.
Right.
Never was able to make contact with the actual property owner, who lives in, I believe it's Birmingham, somewhere in Alabama. My understanding is that the actual property owner that lives in Alabama is the mother-in-law or stepmother to the tenant.
Okay, but you've had discussions with the tenant to let
Plenty
at least
of,
let
yes,
that
sir.
person know what they need to do to bring the property in compliance?
Yes, sir.
Okay.
Yes, sir.
All right. What's the county requesting?
30 days to bring the property in compliance, or $100 per day fine, as well as the admin fee of $73. I think I got it right that time.
Okay, so 30 days to bring the property into compliance. What date would that be, Gina? All right, thank you, sir. At this time, I'll close the evidence portion of this hearing. Make the following findings of fact and conclusions of law. I'll find that the property listed as at 417 North County Highway 393, Santa Rosa Beach, Florida, is owned by Deborah Christopher and is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented this morning, that I do find that there is sufficient evidence to show the violation of 7.02.01 junk and litter of the Walton County Land Development Code. Based on the county's request, I'll require that the property be brought into compliance on or before December 12th. And in the event the property is not brought into compliance, a $100 per day fine will be imposed. In addition to the fine, there's an $84 administrative fee that will need to be paid within 30 days, regardless of whether or not the property is brought into compliance. I've signed that order. Our next case is CE 25-01553. Property owners listed as Carlos and Medea Cano, C-A-N-O. The address is 366 North County Highway 393 in Santa Rosa Beach, Florida. Is there anybody here for the Canos? Okay, great. Are you Mr. Cano? Okay, good. So you're Carlos?
I'm Carlos.
Okay, and who's with you?
My name is Jared Hoganson. I'm his contractor's representative.
Okay. You guys have seen how we've been doing this. I'll let the county present. and then you guys can come up and, you can ask questions, present any evidence. All right, so if you want to grab a seat real quick.
Sorry about that.
All right, good morning.
Good morning. My name is Officer Justin Sloan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony regarding case 25-01553. This property is located at 366 North County Highway 393, Santa Rosa Beach, Florida 32459. Parcel number is 262S20332100000G0. The property owners are Carlos and Nadia Arana Cano. This property is in the unincorporated area of Walton County, is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 1.13.06 post-permit changes and 1.13.09C building permits. The complaint was living in camper, several living in auxiliary unit, and commercial business operating at residence. On June 25th, 2025, I conducted an initial inspection and found no evidence of a business being run from the property. I did find pavers in the backyard without a permit, an RV being lived in with pavers in front of it, an outdoor shower area without a permit, and a concrete driveway that was permitted to be gravel. Further follow-up inspections found the RV and pavers in front of it removed. On June 26, 2025, I hand-delivered a notice of violation with the compliance date of July 2026, and an affidavit was completed. On October 3rd, I posted a notice of hearing to the property at the courthouse and sent a notice of hearing via certified mail. On November 7th, 2025, an application for a BPR was submitted to the Planning Department for review. This property was not brought into compliance within the allotted time. Proper notice was given as prescribed by code. As of the last inspection on November 8th, 2025, this property remains in non-compliance. I request the magistrate find this property in violation. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I'd like to submit my packet into evidence.
All right, that'll be accepted into evidence. Do you guys have a copy of his packet? All right. And so the violations that we're dealing with this morning are 1.13.06 post-permit changes and 1.13.09C building permit. And it looked like from the information provided by the county, they are working with planning to get an
Yes.
after-the-fact permit?
Yes.
Okay.
So as of this morning, the building permit part will, that part has came into compliance, but they didn't meet their compliance date, of course.
I'm sorry, say that last part again.
So they did not meet their compliance date.
Right.
But as of this morning, the building permit part will fall off.
Okay, so 1.1309C, based on what you've seen and observed, that the building permit has been issued for the property?
They won't need one. The violation has been removed.
Okay. So does that mean the only thing we have before us this morning is 1.13.06? Okay, so this is a property that was, the county is bringing before me to show that it was previously out of compliance. And as we sit here this morning, the property is now brought into compliance, but in the event it goes out of compliance again based on the exact same code violations, you want me to designate, while no violation exists on the property and no fine, that if something happens for the same violations of the same code, you can bring this before me as a repeat violator? Oh, the BPR hasn't been approved? Okay, well then that changes a little bit. All right, understood. All right, anything else?
No, sir.
All right, do you guys have any questions of him? So it sounds like he's saying that the building permit is issued?
It's no longer needed.
No longer needed, rather. Okay.
There was an outward
Oh, okay. So that would be the one with the
Post-permit
post-permit changes. So I'm free to mark off on this draft order, the 1.1309C, correct? Right. Oh, so you want to leave that on there for the repeat potential? In case they do something else that they need a permit for? Okay. All right. I'll hear from, Mr. Cano, or, I'm sorry, how do you say your last name? Hoganson. Do you have any questions for the officer?
No, the only request I have is if I can get extended time to finish the project because it's still on planning for the stormwater.
Okay.
If I can get 90 days.
All right. You think 90 days will give you enough time to get everything done? Mr. Hogan's is nodding his head.
Hopefully. Sometimes they take forever.
Understood. But it sounds like you guys are pretty close. But does the county have any comments on the requested 90 days to bring the property into compliance, or what's the county's recommendation?
I would recommend 61 days or $100 per day to accrue with a $73 admin fee.
All right, so the county's asking for 61 days. The property owner is listed or requesting 90 days. All right, anything else I need to consider, gentlemen? All right, thank you both. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property listed at address at 366 North County Highway 393, Santa Rosa Beach, Florida, 32459 is in the unincorporated area of Walton County, Florida, and is therefore subject to the Land Development Code. I'll find that based on the evidence presented this morning, there is a violation of 1.13.06 post-permit changes. I will make the additional finding at the request of the county that there was a previous violation of 1.13.09C building permit, but I will not at this time issue any fines related to that. However, if there is a future violation of 1.13.09C at this property, that that will be considered what's called a repeat offense, and that means they can expedite bringing it here. Doesn't mean you don't have a hearing, just means they can bring it here a lot quicker than they would normally do it. All right.
All right.
So there's no fine that's going to be imposed when I get to it related to 1.13.09C. I do find that because there is a violation 1.13.06, that the property must be brought into compliance, and I will provide the request of Mr. Cano, the property owner, for the 90 days. That'll put us February what? February 10th of 2026. In the event the property is not brought into compliance on or before February 10th, 2026, a $100 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That $73 administrative fee will need to be paid regardless of whether the property is brought into compliance, and you'll have 30 days to pay that. So go ahead and pay that. If you get everything done with the county on your permit or BPR, great. You still got to pay the $73. All right.
Sure. And
then I am marking on here a third box that, and this is going to be specific to 1.13.09, and this is the part I told you that if you have another violation as it relates to that specific code for failure to get a building permit, then they can bring you here as a repeat violator. But again, no fines on that. Nothing really for you to do other than just follow the rules, so to speak. All right.
Thank you.
Are there any questions regarding the order?
No.
All right. Anything I missed, County?
Yes, sir.
All right. Thank you, gentlemen. Y'all
All
have
right.
a good day.
Thank you. All right. Appreciate it.
All right. Our next case is CE 25-01711. Property owner is listed as King Construction Group, LLC. And the address is listed as, on Sally Lane, Santa Rosa Beach, Florida. I'm assuming since there's no 911 address, this is maybe a vacant
It's
lot.
it's supposed to be a vacant lot, yes, sir.
Yeah, parcel numbers 24 2S 21 42 000 008 0010. Is there anybody here on behalf of King Construction Group LLC? Okay, not seeing anybody. Whenever you're ready, go ahead.
My name is Officer Justin Sloan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony regarding case 25-01711. Property located at Sally Lane, Santa Rosa Beach, Florida, 32459. Parcel numbers 242S 2142000 008 0010. Property owners King's Construction Group LLC. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 1.1300 development approvals. The complaint was construction equipment containers on the corner of Mac Bayou and Sally Lane. Complainant states it's an eyesore. On August 28th, 2025, I conducted an initial inspection and observed unregistered vehicles, Connex boxes, and construction materials on the vacant parcel. The stop work order was placed on August 28, 2025. On August 29, 2025, the notice of violation with a compliance due date of September 30th, 2025 was sent by certified mail to the property owner and address listed on the county's tax collector's website. I also posted a copy of the notice of violation to the property, and an affidavit of service was completed. On September 3rd, 2025, Tim from King's Construction came by the office and I advised him on how to correct the violations. Tim said he was going to speak with the planning department, but there's been no communication with him since. On October 3rd, 2025, I posted a notice of hearing to the property during a follow-up inspection that revealed all violations were still present. A notice of hearing was also sent via certified mail and posted at the courthouse. This property was not brought into compliance within the allotted time. Proper notice was given. And as of the last inspection on November 8, 2025, this property remains in non-compliance. I request the magistrate find this property in violation.
All right, thank you, sir. What's the county's recommendation as far as timeline to bring the property into compliance? Fines?
26 days, which is December 8th, to achieve compliance, or a $100 a day fine to accrue with a $73 admin fee.
I'm sorry, say that December what?
December 8th, which
okay.
is 26 days.
And what was the fine amount? I'm sorry.
100.
100?
Yes, sir.
Okay. All right. Also accept into evidence your report and backup materials. All right, thank you, sir. I'll ask one last time. Nobody from King Construction Group LLC. All right. I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property with the parcel ID number 24 2S 21 42 000 008 0010 on Sally Lane in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony evidence presented, I will find that there is sufficient evidence to prove a violation that has occurred at the property, specifically a violation of 1.13.00 development approvals. Based on the request of the county, I will find that the property must be brought into compliance on or before December 8th, 2025. Should the property not be brought into compliance on or before that date, a $100 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That administrative fee will need to be paid regardless of whether the property is brought into compliance, and the property owner will have 30 days to pay that. And I've signed that order. Next case is CE 2501426. Property owner is listed as Stan and K. Walker. The address is 127 New Providence Lane, Inland Beach, Florida. Is there anybody here on behalf of Stan and K. Walker? Are you Stan and K. Walker?
Good morning,
Morning.
Magistrate Dykes. My name is Barbara Reisberg. I'm with the law firm of Taylor Duma. I am here on behalf of the owner, Walker Beach House, as well as on behalf of Kay Walker, who is named in the notice of violation. Unfortunately, Stan Walker passed away about 6 weeks ago.
Oh, okay. Well, hold on one second. Let me get the right packet. All right. So, condolences regarding Mr. Walker. So, we have Kay Walker, you said, and you said, who was the other?
The deeded property owner is Walker Beach House LLC.
Okay.
And I have with me a witness, Mike McGrath, should testimony be needed.
Okay. Well, and your last name's Miss Riceberg?
Yes, RIESBERG.
All right. Thank you, Ms. Riceberg. We'll go ahead and allow the young grab a seat right there at that table if you like. And what we'll do is kind of like what you've seen already. We'll allow the county to present. You can present any evidence. And then we'll kind of go from there. And I believe, and what's that gentleman's name? I'm sorry. McGrath, and I believe I saw you come in. You were stood in the doorway and were sworn in earlier. I thought so.
He was.
Yeah. All right, I just wanted to get that on the record because I thought I saw you. All right, and I know we have a representative for the adjacent property owner that's here. You want to go ahead and come up? State your name for the record and who you represent.
Thank you, Mr. Dykes. Magistrate Dykes, Lee Strahan here on behalf of Norman and Darlene Bobo as trustees of the Adventure Capital Exempt Trust, that is the record title owner of the residence that's adjacent to the subject property. And my client's residence is 133 New Providence Lane, and the subject residence of the complaint is 127 New Providence Lane.
All right, thank you. And correct me if I'm wrong, either Ms. Riceberg or Mr. Strahan, there's current litigation going on, correct, regarding the property owners?
Yes, that is correct. The Adventure Capital Trust, which is owned by Norman and Darlene Bobo, has filed suit against the Walker Beach House, Kay Walker, and Stan Walker.
Okay, I just wanted to kind of lay that groundwork. Obviously, we're not in a court of law today, so I'll just ask that both attorneys recognize that, we're not here to litigate what might be going on there. We're only dealing with the alleged code violation. So I'm going to try to give everybody an opportunity to proceed, but like I said, I'm not equipped or provided the authority to rule on what may or may not be in the pending litigation. So if we can kind of stay in our lane, I just want to kind of lay those ground rules. That goes as well for the county, and I'm going to try to do the same and stay in my lane.
Very much understood.
Okay. All right. With that, with those ground rules in place, whenever you're ready.
All right, I'm Code Compliance Officer Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 25-01426. This property is in the unincorporated area of Walton County and subject to Land Development Code per Florida Statute, Chapter 162. Location parcel is 35-3S as in Sierra -18-16062 -024-0020, excuse me. Also known as 127 New Providence Lane in Inlet Beach, Florida. The violations cited are 1.13.008 alpha development approvals and 1.13.06 post permit changes. The initial case was opened on 5/7/2025 with me conducting the initial inspection on 5/8/2025 and also placing a stop work order on the parcel on that day. The contractor And the other representation here, they were both present at the site, and I guided them toward getting the proper documents turned into planning for review. And then the initial BPR, or building review, was submitted on 5/12 of 2025, a matter of a few days later. There was continued inspections completed by me to verify the start work order was being adhered to, in which they have been through the process. And on 6/21/2025, a notice of violation was placed on the property. It seemed the review process that came to a stall, and later found out on 7/22 that there had been civil litigation brought into the parcel, creating the stall, and then them obtaining the documents needed from the Rosemary Property Owner Association for the architectural review. On 7/31/25, I received verbal confirmation from the Rosemary Property Association that the litigation, and I made the determination to move forward with the code compliance due process. And after confirming that date of any more documents being released and being unknown, I prepared a notice of hearing on 8/21/25, with it being mailed and posted to the property for the October 8th hearing. Then on 9/23/25, I received information that Mr. Walker had passed away, with an extension request beyond the October hearing, and I then extended the hearing to this date, along with sending out a new posting and updated notice of the date. And just recently on 11/4, I received information that the Rosemary Property Association had approved and released the architectural review, with me advising the owner's local contact that the entire packet would have to be resubmitted due to the previous having been closed in the portal due to the time delay. And the updated packet is now showing to be resubmitted for review as of 11/7 under a new BPR number ending in 4796. On 11/10/25, I did a pre-hearing follow-up in the late afternoon, still finding the start work order being adhered to, and I wish to submit my report and statement into evidence.
I'll accept that into evidence. Are there any comments from Ms. Riceberg or Mr. Strahan regarding the county packet?
I just want to make note for the record that there is a July 21st letter from the Rosemary Beach POA, essentially stating that all plan review would be suspended due to the litigation that had been threatened against the POA. A lawsuit was filed by the adjacent property owner, Adventure Capital Exempt Trust, on August 2nd. Notably, the Rosemary Beach POA was not named as a party.
Well, and my question more is, do you have any objections or comments related to the packet that the county's seeking to put into the record? Okay, so nothing from Ms. Riceberg, anything from you, Mr. Strahan? As far as just the packet, I'm just, okay. Well, if you don't mind, walk up here to the microphone. I know it's a little cumbersome. We do record these, though.
Yes, sir. Apologize. No objection to the packet, Your Honor. I just want to, we did bring a report from Arcadia, our expert, and regarding the plans that were submitted to building and planning, and wanted to submit those today. I didn't know if those were contained in the packet or not.
I don't know that they are. I don't see them, are they?
They are, well, the PDF to it, I just received it this morning. The PDF is attached to the file, but our printout for this doesn't show all those images.
Okay. So I think maybe some of it is, but maybe not the stuff that you have. So we'll give you an opportunity if you want to put that.
That's more on the lines for planning or them to review over code here.
Yeah. Okay. Yeah. And all right. So if there's nothing regarding the packet, now I'll open it up. Ms. Riceberg, do you have any questions for the county? And then I'll allow Mr. Strahan if he has any questions. You have any?
Yes.
Go ahead. Yeah. Go ahead.
Shall I refer to you as officer?
However you want,
Okay.
Greg or officer, however you want to do
Okay, officer, are you aware that plans have been resubmitted
it. Yes.
and they are being reviewed by planning?
According to the, what I can see in the portal, they're up for review. I don't know how long it might take them to get in line, but they are resubmitted with, I've seen the joined, release from the property was also in this packet from the Architecture Review Board.
And prior to today, were you aware that the POA approval was what was preventing the county from approving it?
Yes. We were probably 85–90% near closure, and then once the litigation started, they discontinued releasing any documents, I guess, for whatever reason within that side of civil side of things.
Okay, based upon your experience, would you agree that planning approval should be forthcoming within the next 90 days, if indeed planning has
I would
received
think
all
so.
documents?
I can't guarantee what they have, on their agenda, what they have before them to approve. So I can't say it'd be there, but I would assume, given it was so close and all they had to do was add that one portion to be reviewed, from the looks of it, from what I was told there through the prior planner, that's all there was waiting on was that approval, and then it stalled at that point. And I would think with a full packet, I can't guarantee how long it would take, but it should be a reasonable, not very lengthy.
And upon approval, would there be compliance with the violation?
As long as they approve it over there in planning department and they do exactly what's on the documents that they say they're going to do, that's all that'll be needed.
Thank you.
All right. Mr. Strahan, do you have any questions for Mr. Forhan?
Mr. Forhan, you had the ability, obviously, to inspect the subject property and the, what was the specific structure that what you were inspecting?
Well, I just went there on the complaint of the activity, and they had started the activity without any approvals through the county. And from what I was gathered, they had contacted the building department and was told nothing would be needed due to it them considering a fence or a stem wall, but they still require planning review due to any alterations that may change the footprint or stormwater and things such as that to make sure it holds to the original development.
And this house is in Rosemary Beach on a 0 lot line?
On a 0 lot line, yes, sir.
And did you observe that the structure at issue that is subject to this dispute that is now going to be rebuilt, was it a portion of it attached to the home of my clients?
Well, it appears on the east and west sides, yeah, there's an attachment between the garden and foyer space. But I'm not an engineer to know. That's outside my wheelhouse completely.
Have you ever seen anything like that?
No, that's my first one I've ever had on a new lot, on a new line.
Okay. With respect to this, I had a Arcadia, our expert submitted a report just to comment on building and planning's review in terms of the plans submitted by we just found out about this last week based on the pending litigation. There were some initial disclosures that we saw this evidence of this hearing. So we asked our expert to comment on the plans that were submitted that we just newly discovered. And we submitted a copy of this report. Did you get an opportunity to review this report?
Not in detail, but I did forward the PDF and that email to Stephen Shawn and the planning department and the prior planner, Jesus, for them to have, because it was just sent to me and my deputy director, Michael Gainey, and I didn't see anyone from planning attached, so I did forward that to them, being that's more under them to look at and take into consideration.
And do you think it would be reasonable for the concerns addressed in here to be subject to review by building and planning?
Potentially. I mean, that's what you mean. If you want to discuss anything with them, I did direct you there.
Sure. Okay. Thank you. That's all the questions that I have for Mr. Forhan, but I would like to just make a couple comments for the record.
Okay, well, hold on. I'll let you do that in a moment.
Okay.
All right, so anything else, Ms. Riceberg, based on questions by Mr. Strahan to Officer Forhan? Yeah, any follow-up?
Officer, are you aware of correspondence from Jeremy Brook as a stormwater consultant for the county? Okay, I'm going to show you a copy of, excuse me, I don't have that with me. If a letter had been submitted to the county by a stormwater engineer, would that be in the planning file?
I would think so. That's outside of our, we just go there to review what the complaint was, ascertain what's there, and then pursue it in what manner we do, which will put in the stop recorder on it, and they've done that. So, and they haven't went any farther with it.
Okay, no further questions.
Thank you. All right, Mr. Forehand,
Yes, sir.
do you have anything else? All right, at this time? All right, go ahead and grab a seat. Ms. Riceberg, do you have anything that you want to present on behalf of the property owner?
I would like to present the testimony of Mike McGrath, who has been working on behalf of the property owner to ensure all submittals have been sent to the county planning department.
Okay. Mr. McGrath, you were sworn in earlier. If you want to come on up to the podium, and I'll allow Ms. Riceberg to ask you whatever questions she likes.
Mr. McGrath, are you aware that the planning department has received submittals for the plans for 127 Providence?
Yes, ma'am.
And to your knowledge, was the prior file closed?
Yes, ma'am.
And why was the prior file closed?
They didn't receive the approval letter from the POA, as stated about the pending litigation.
And to your knowledge, the approval letter from the Rosemary Beach POA has now been submitted to the planning department.
Well, real quick, just so the record's clear, POA stands for?
Property Owners Association.
Right,
Rosemary.
is that kind of like their ARB?
Pretty much, yes,
Okay.
sir. The ARB falls within the POA.
Okay, just wanted to have that clear. I know y'all are using that acronym. You and Mr. Strahan understand that. I just want to make sure that everybody else does. Go ahead.
Yes, sir.
And Mr. McGrath, is it your understanding that once the plans are approved, the project will be completed based upon the approval from the county?
Yes, ma'am.
Okay, I don't have any further questions.
Okay. County, do you have any, Mr. McGrath, don't run off, just in case. Does the county have any questions for Mr. McGrath? All right. Mr. Strahan, I'll give you, do you have any questions for him? Again, we're going to limit it just to what was asked by Ms. Riceberg.
Mr. McGrath, are you the representative for Stan and Kate Walker or the Walker Beach House?
I wouldn't say I'm a representative, no, sir.
Did you represent them in any negotiations with the Rosemary Beach Property Owners Association with respect to securing their authorization to reconstructing this aesthetic feature on their courtyard?
I assisted them in helping submitting documents, yes, sir. But that was more done as a friend and not a representative or a contractor of any sort.
Okay, so who is their project representative for this project?
The contractor is Claudio Rock.
And is Claudio Rock also been communicating directly with the Rosemary Beach Property Owners Association?
I wouldn't say he's been communicating directly, no, sir.
Who directly communicates on behalf of the Walker Beach House?
It would be Victor Logan or myself as well.
Okay. So you have some representative capacity to represent the owner, or do you not?
I think it could be defined differently on how you state that, but yes.
Okay. So, and approximately this matter, there's been water intrusion from the previous structure that was attached to my client's home. That was back in about a year ago.
Yeah, I agree. I tend to agree, Mr. Strahan. You can ask Mr. McGrath related to what he's helped submit, things like that. But I mean, again, we're not going to litigate y'all's other stuff today.
Sure. I understand. I just wanted to make sure.
Understood.
I understand. You know, how long this has been going on, and you know what authority he has to
Well, I think he said he had authority to submit some documents. If you want to ask him what documents he submitted
Yeah.
for the property owners, I think that's fair game.
Sure.
But I'm not going to have him testify to claims of water intrusion and
Sure.
things like that. I mean, that can be sorted out in depositions.
Sure.
In the other case.
Well, what authority, who authorized you to make the submittals on behalf of the Walker Beach House?
The Walker Beach House.
Okay, and who, the Walker Beach House being an entity, LLC, who on behalf of the Walker Beach House?
A manager of Walker Beach House.
Okay, and who was that?
That would have been Victor Logan.
That's all.
Didn't submit or agree or approve anything. It was simply sent to them and then processed as well.
Yeah. That's
When
all.
you say sent to them, who's them?
Like approved by Walker Beach House LLC and then POA, whether it's between vendors or anything like that.
Okay. All right. Anything else?
And it's in conjunction with that role. Did you also work directly with Stan and K. Walker?
As a friend, yes, sir.
That's all the questions I have at this time for this witness. Yeah.
Yeah, thanks. Ms. Riceberg, any quick follow-up? Again, let's try to keep it fairly quick and to the point.
So, Mr. McGrath, you were asked about whether you represented Stan and Kay Walker in submission of documents. Is that correct?
Yes, ma'am.
And to your knowledge, do Stan and/or the late, Kay and/or the late Stan Walker have any ownership interest in the Walker Beach House?
I can't answer that.
So when you said that you were acting as a friend to the Walkers, would it be fair to say you weren't stating that you were representing them with respect to the property?
Yes.
Okay.
All right. Anything on that very narrow area of representation, Mr. Strahan? No?
Back.
Get closer to the mic. There you go.
Okay, sorry. Mr. McGrath, are you the realtor for Walker Beach House LLC?
I was when it was listed for sale, yes, sir.
Okay, and is it currently listed for sale?
No, sir. No contract is signed or engaged in.
Is the intent to list it for sale now?
I can't answer that.
Okay. And so your capacity in conjunction with the submittals have nothing to do with you being the realtor for this property, past or present?
No, sir.
Okay, thank you.
All right. All right. Thank you, sir. Anyone else, Ms. Riceberg, that you want, or any other witnesses or evidence you want to present this morning?
No further evidence.
Okay, thank you. Mr. Strahan, I'll give you a little bit of time. You said you wanted to maybe put something in the record or make a statement, but again, just keeping it relative to the code compliance issue.
Yes, sir. Thank you, Magistrate. The only comment I would like to submit the Arcadia report into the record for evidence, just and request that the stop work order be extended or stayed until building planning review has an opportunity to review the report, because there's comments about the drainage plan that I believe are important for review, since we had not seen the latest submittals to Rosemary Beach Property Owners Association that was submitted to building and planning review. Therefore, we would ask that we have an opportunity to submit comments from our expert before the stop work order is lifted.
Okay. So looks like there's two requests. The first one we'll deal with is this, is it an engineering letter? Or?
Yeah, it's a professional construction expert, is a licensed general contractor who is an expert in Todd Alford.
Okay, so I'll allow Ms. Riceberg to speak to that in a moment, but it's my understanding that's already been submitted into the county's portal. Is that correct? Understood, but I'm saying, has it been uploaded or is it?
I've sent the email to Stephen, the email they sent me.
Okay. With that attachment? Okay. So it's been submitted to the county through an email from Mr. Strahan's office? Is that correct? All right, and that went to a county email address? Okay, so now that's a public record under 119 Florida statute. Okay. Ms. Riceberg, I'll hear if you want to make argument, but I'll go ahead and tell you I'm going to allow it in since it's been submitted to the county. It's a public record. You know, if there's confidential information that can be, you know, withheld or redacted. But I mean, once it's been submitted, it sounds like it's hit the server.
Well, I'd like to note my objection to it being considered as part of this code enforcement case. I agree that it's something that planning may review, but for purposes of this code enforcement case, I don't believe it is appropriate.
Understood. All right. Well, I'll accept that into evidence. Ms. Strahan, if you want to approach and give that to me. All right. And I'll mark this as, we'll just say Publix Exhibit 1, and I'll give this to the secretary. All right. And then the other request was a request to extend the stop work order. I don't even know that I have the authority. I don't have authority to tell them to issue stop work orders or tell them to revoke stop work orders. So I don't know that I can even honor that request. I think that's going to be an administrative issue for the county on whether or not to continue a stop work order or not. But I'll be glad to hear if you think I have authority where that's at in the code, because I've never had that request before.
Okay. Basically it's under just a health, safety, and welfare concern, because the feature that is going to be reconstructed has caused damage. And that's what the subject litigation is about. We want to get into that, but it has caused water intrusion damage and mold and mildew and substantial issues that are in dispute. But with respect to this feature, that we think it's important to get it right, because it was, you know, a real nuisance and before, which, you know, we need to make sure that the waterproofing and design is perfect, because it is previously was attached to my client's home. Now it is going to have a stem wall, but we still need to make sure that there are certain aspects of this wall that are going to have the proper waterproofing design. So there is a major concern about the this aesthetic feature affecting previously being attached to a residential home as the rear of its rectangular wall. Instead of having its own self-contained wall, it used the back, my client's home, as its rear wall. So quite frankly, never seen anything like this before in my career, where someone attaches a raised planter bed to a home. But nonetheless, there is significant concern here about the fact that there's an aesthetic feature that's not necessary, and it is already impacted my client's home substantially, which caused the litigation, which there's injunctive relief sought in there as well. But the fact that there's already been a problem raises our concern over the new design, and that it be so important to my clients and the public that this be done in a manner in this zero lot line environment where it can ensure that there will be no further risk of water intrusion.
Ms. Riceberg, I'll be glad to hear from you on his request.
Yes, with respect to the request, I would object to it being granted. I agree with this body that it's beyond the authority of this code enforcement hearing and you as the magistrate. There's nothing in the code to allow for this. This is something that is better handled by the planning department of the county. I would also request that Walker Beach House be given an additional 90 days to come into compliance with all approvals from the county.
All right, thank you, ma'am. All right, thank you, Mr. Strahan. What's the county's recommendation on this? You've heard Ms. Riceberg's request on behalf of the Walker Beach House LLC. They're requesting 90 days. What's the county's position?
Given the inability to predict it, I have no issue with the 90 days because they've been adhered to everything I've requested to this point.
Okay. Thank you, sir. The I will go back and find that I do have concerns. I don't believe I have authority. I'm not familiar in the code. Somebody wanted to direct me to the code where I can issue and stop work orders and revoke stop work orders. I'd be glad to look at that, but I've never seen that.
Typically, how a stop work order works is we won't lift it until all approvals or any permits are granted.
Right. I also find that, I appreciate Mr. Strahan mentioning this because I was going to ask this question. It sounds as though if you believe it's a health, safety, and welfare issue, you are seeking injunctive relief through the courts. That's probably the better avenue than me myself dealing with that, where you can present evidence from Arcadia ICR and Mr. McGrath or others can testify before the court as to irreparable harm and things like that are required for injunctive relief. So I will not honor, I'll deny, however you want to phrase the request to require that the stop work order be remain in place or lifted. I'll allow that to continue to be controlled by the county. All right. Is there anything else from the county? All right. Anything else, Ms. Riceberg or Mr. Strahan? No? All right. Thank you both. At this time, I'll close the evidence portion of this hearing. Based on the testimony and evidence presented, I'll make the following findings of fact and conclusions of law. I'll find that the property listed at 127 New Providence Lane, Inlet Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is sufficient evidence to support that a violation has occurred at the property, specifically 1.13.00A, development approvals, and 1.13.06, post-permit changes. Based on the county's recommendation and the request of the property owner, I will provide that the property must be brought into compliance within 90 days. That'll put us February 10th.
With the admin fees of $84.
Right. Okay. So the property will need to be brought into compliance on or before October 10th, 2026. If the property is not brought into compliance on or before that date, what was the requested fine?
$150 a day.
$150 per day would be imposed. Good news is, sounds like everything's been submitted, so now you're just at the mercy of the county. There's an $84 administrative fee that will need to be paid regardless of whether or not the property comes into compliance. You'll have 30 days to pay that. And I've signed the order. Any questions regarding the order? I will put into the record, in case anyone wants to seek an appeal of this order, what I've marked as Exhibit 1, public, the Arcadia ICR, and as I stated earlier, I accepted into evidence the county's staff report and records presented. All right. Any questions regarding my order? Anything like that? County, Ms. Riceberg, Mr. Strahan, anything? All right. Thank you all. Best of luck to you. And you guys are released. Sorry y'all had to stick around so long. Yep. The last one I believe that we have is case number CE 25-01436. And that property owner is listed as Jacy, Jacy, Anne, A-N-N-E, Blackwell. And the address is 301 Kayley Road, Kaylea Road, Freeport, Florida. All right. Are you Miss Blackwell? Okay. Good morning, Miss Blackwell, or afternoon. You got the shortest of all the straws. You had to stay here till the very end, it seems like. So, Miss Blackwell, were you sworn in earlier? Okay. Then we'll do just like we just did. We'll allow the county to present. You can ask questions, and I'll hear any testimony or evidence you want me to consider. All right? Whenever you're ready.
Okay. I'm a Co-Compliance Officer Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 25-01436. This property is in the unincorporated area of Walton County and subject to Land Development Code per Florida Statute Chapter 162. Location of the parcel is at 17
1 Sierra 1814000010170, also known as 301 Kalia, that's what I usually call it, Kalia Road, Freeport, Florida 32439. Violations cited are 50709C for junk debris and vehicles, 202.00P RVs and campers, 1.13.00A development approvals, and 1.13.09C building permits. The complaint was received on 5/8/2025 in reference to the prior mentioned violations, with research completed and attempted owner contact by phone from a prior contact number I had for her. The initial inspection was performed on 5/21. On 5/27, notice of violation was prepared and mailed along with posted to the property on 5/29/25. On 6/6/25, there was a meeting held at planning with Co-Compliance Supervisor King, Ms. Paula Mazan, and Mrs. Blackwell here. In my absence, they were able, Ms. King was able to get updated contact information, and me and Ms. Blackwell has been contacting quite frequently ever since. There has been gradual improvements along the way, but with the time that has passed, prior process, a notice of hearing was mailed on 9/4/2025 and posted on 9/23. And we had a follow-up meeting on 10/28 where Mrs. Blackwell was able to gain more information from Ms. Kelly Schultz and Ms. Donnie's Way at planning, along with discussing the allowance and shielding of the parcel due to its zoning location. Through extensive communication, Ms. Blackwell advised of her situation and intentions, but the time allowance will not grant her the means, both financially and physically, in being able to complete the tasks needed. She's been moving forward as resources has allowed in removal of non-running vehicles shortly after on 7/16/25, and she has recently, in the last week or so, removed one of the RVs. So, and those updates do show in my pre-hearing photos of the areas where those items were removed. I do wish to submit my report into evidence.
All right, that'll be accepted into evidence. Ms. Blackwell, do you have any questions for Officer Forehand? Okay, great. Mr. Forehand, if you want to grab a seat then, and Ms. Blackwell, this will be your opportunity to present any testimony or evidence you want me to consider.
I am asking for consideration. I did lose my husband prior to all of this. The sea containers in mention were and would like to still be used as building materials. I do have 27 years of family heirlooms and furniture in them. But they are going to be, at some point, they will be used to build my house. Those things will go into a storage unit while the house is being built. I'm in litigation against the man who hit and killed my husband. And as you know, those type of things take time. And I do not have the financial means to change the situation other than to remove any junk and old things that I have let become decrepit during the time. And I'm asking for leniency and time. And once the case comes to a completion, I will either A, have the finances to remove everything and sell the property, or the finances to build the home that I'm expecting to.
Yeah, and I understand, and I'm not opposed to giving you some additional time, but what I would point out is, this has been going on since May. And while I understand you have some some other matters going on, you know, with your lawsuit and the loss of, you know, your husband. You know, it has been several months. So, do you have the ability to maybe get these things put into storage beforehand, or store them somewhere else where somebody can, you know?
So you do realize how much storage costs in Florida?
I know it's not cheap. I don't
Okay.
have storage, but
So those things, you know, they're holding lifelong memories, and they're not really hurting anybody.
understood, ma'am. But we do have code, and there's no home on the property. There's no, there is some other issues. So, I mean, again, I'm not opposed to giving you some additional time, but we won't have indefinite. You know, that's not going to be the answer for today.
Well, I would hope it wouldn't be indefinitely.
And we're also not going to tie it to your current personal injury litigation, because as you pointed out, that can take several years to work its way through the system. So, again, I'm more than happy to try to work with you, but again, you're going to have to work with the county on this. So how much time do you think you need?
Well, it won't be for at least 6 months.
Okay. So you think that you'll have the property in compliance in 6 months?
I'll do the best I can.
Okay. Well, I mean,
at that point, I don't have the answers for you.
okay.
If I had the answers, I'd already have it fixed.
Understood. And I mean, look, you don't have to have them fixed today. But what I am saying is, you know, we do need a reasonable amount of time, and I'm glad to hear there's been some improvements to the property, you know, things that you have been able to resolve. I will tell you, I don't have the authority to go 6 months out. But what I can do is look at 90 days. That's 3 months. And I don't know if you were here at the beginning, but, you know, you can seek a fine reduction, assuming you go past that 3-month period. I mean, I guess what I'm telling you is I'll give you the most amount of time I'm allowed to give you under the code, but I can't go beyond that. So, does the county have any comments or anything, any objections to trying to provide Miss Blackwell the maximum amount of time?
No, sir. I was actually going to propose the 90 days given her situation.
Okay. And then does the county have any other recommendations related to fines and
given her status, I think $75 a day will more than promote her to try to get things done in a timely manner, and with the 90 days. So we should put it at the February 10th again.
All right, and then I see you have listed $73 in administrative fees.
Yeah, for the administrative fees, yes, sir.
All right. So Ms. Blackwell, you've heard from the county. They're not opposed to giving you, and I'm not opposed to doing the maximum amount of time. They're requesting $75 per day, and
that's after the 90.
Correct.
Yeah, that's after the 90.
So those don't start today or tomorrow. Those would be February 10th, I think, after February 10th.
I have zero means to make this happen right now, so it will just end up being the fact that you all probably will take my land.
Okay, well, if you resolve the matter with the personal injury or wrongful death.
I don't work, and I've applied for disability. I'm living off of $800 a month.
Yes, ma'am. Okay. All right, anything else, Mr. Forehand? Anything else, Ms. Blackwell?
No, sir.
Okay, thank you both. You can grab a seat. I'll go ahead and close the evidence portion of this hearing. I'll accept into evidence the county's report. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented that the property located at 301 Kalia Road, Freeport, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is sufficient evidence to prove that there is a violation of 2.02.00P RVs and campers, 5.07.09C exterior storage and junk and debris, 1.13.00A development approvals, and 1.13.09C building permit requirements. Based on Ms. Blackwell's testimony and the recommendation by the county, will provide Ms. Blackwell as a property owner to bring the property into compliance on or before February 10th, 2026. Should the property not be brought into compliance by that date, there would be a $75 per day fine that would be imposed. As I stated earlier, Ms. Blackwell, even if you don't have the property brought into compliance and you bring the property in compliance after the fact, you can come in and seek a fine reduction. So don't take that as, I guess, throw your hands up and I can't do anything. If you bring the property into compliance 100 days later, you can come in and seek a fine reduction. In addition to the bringing the property in compliance, there's a $73 administrative fee. The administrative fee will need to be paid regardless of whether or not you bring the property into compliance. So, and you'll have 30 days to pay that. So, well, let me ask you, is 30 days too quick, or can you pay that? I mean, would you need 60 days? Okay, well, I will require that be paid in 60 days. So, so the $73 administrative fee, you'll be able to pay that within 60 days, Ms. Blackwell. And best of luck to you. I understand it's a tough situation. Wish you luck. And as I said, take advantage of the fine reduction procedure if and when you get to bring the property into compliance. All right. That concludes that matter, and that shows us concluding all of the cases on my agenda. Yes, ma'am.
I believe one was missed.
All right, which one was that?
Approach.
Yep. Okay. So, yeah, I had this one. So somebody, the owner, Miles Golding.
Yes.
So go back to the, so is it?
It is on our county website on the agenda. I'm not sure how it did not make it onto the agenda that's printed.
All right, so we got case number 2501662. Address is listed as West Highway 20. West Street?
West State Highway 20.
West State Highway 20 West, Freeport, Florida. I'm guessing this is a vacant lot, 191S 2032050.
Yes, sir.
00A 0110. The owner is listed as Miles Golding, and it's your representation that this was properly noticed to the property owner, properly, I guess, would have been posted at the courthouse or
Correct, yes, sir.
county, but it did not make our printed.
It's on the agenda. Just somehow, I think we might have misprinted the one that was published before this one was added to the agenda.
Okay.
I'm unsure, but on the website it is.
Yeah, I don't see it on what I was given, but that's fine if it was properly noticed. I mean, is somebody here for Mr. Golding?
He is not.
Okay. Is there a reason why Mr. Golding might have got confused? Was he here earlier and then
No.
left? Okay. I don't, yeah.
He should have been aware. I certified mailed it. I posted it to the property, and I emailed it to the email address that was on the permit that he has applied with.
Well, let me look real quick. Do you have that in your packet here, the notices?
Yes, sir.
All right. Give me one moment to look at those. All right, I have photographs of a mailing for Mr. Miles Golding at 205 Hammock Trail, and then it gives maybe a unit number, Freeport, Florida, and then I see photographs of a notice of hearing indicating this was posted on October 28th, 2025 on the property. And then I also have a posting at the courthouse of the notice of hearing, giving this case number 2501662, noting that the magistrate hearing will be today's date, November 12th at 10 a.m. and at this location, the Freeport Boardroom, 842 Highway 20 East, Suite 118, Freeport, Florida. And then I see the return to sender certified mail. All right, based on that, I will find that this case was properly noticed for today's date and time, even though it wasn't on the printed agenda I had. I'll allow the county to present on this matter whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regard to case number 25-01662. The property is located at West State Highway 20, Freeport, Florida 32439. Parcel number is 19-1 South-20-32050-00. A as in Alpha. -0110. Property owner is Miles Golding. The property is in an unincorporated area of Walton County and is subject to Land Development Code Chapter 7 and the county ordinances. Violations cited are 1.13.00A development approvals and 1.13.09C building permits. On August 7th of 2025, our office received a complaint stating that the cleared property and brought in fill in the wetlands, and no permits were pulled. On August 12th of 2025, I conducted an initial inspection and found that the property had been cleared and fill dirt brought in. When looking at the Walton County interactive map, it shows that the majority of the lot is wetlands. I posted a stop work order and DEP was contacted. On August 13th of 2025, a notice of violation was given as prescribed by code. On August 19th of 2025, I spoke with Rick Abad with DEP by phone, and he stated that the wetlands had not been impacted, and that he was told by the property owner that he had obtained a septic permit. I received an email from Rick with the septic permit attached, which is in your packet. That same day, Mr. Golding came to the office and we spoke about the violations. On September 23rd of 2025, I contacted Mr. Golding by phone, and he stated that he had hired a general contractor that is working on the permit to build. On 10/28 of 2025, a notice of hearing was given as prescribed by code, and on 11/03 of 2025, I found that Mr. Golding has applied for a clearing permit, which is also in your packet. Photos in your packet show that the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
That'll be accepted.
Thank you.
All right, what's the county's recommendation on this?
30 days to achieve compliance, or $250 per day fine to accrue with a $73 admin fee. And I do want to be clear on the record, even if he gets a clearing permit approved, he would need to remove the fill dirt off of the property if he does not intend to build at this time.
That require a restoration plan and stuff?
Possibly. If they approve the clearing permit and he does not intend to build, he would need to remove the fill dirt. If he gets a clearing permit approved and he wants to keep the fill dirt, he would need to obtain a BPR, a building plan review, and then also a building permit to resolve the violations.
So would all the fill dirt be required to remove, or just the portion that's maybe impacting the wetlands?
All fill dirt would have to be removed.
Okay.
Because to be able to bring fill in, you would need a building permit to do so.
Okay, I understand. But that would be told to Mr. Golding through planning or through your office?
Depending on which way he wants to go. Now that he's applied for a clearing permit instead of a building permit or a BPR to build, he's changed directions, and I haven't talked to him since that last conversation in September.
Okay. Well, I guess, as you said, we'll allow Mr. Golding to go through planning and then decide which, so it may be a non-issue, but if.
Correct, yes, sir.
Okay. All right. Thank you, ma'am. As I stated, I'll previously, I'll accept into evidence the packet and report provided by the county. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at West State Highway 20, Freeport, Florida, undeveloped lot, parcel ID 19-1S 2032-050-00A-0110, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find sufficient evidence to support that a violation has occurred at the property, specifically a violation of Walton County Land Development Code 1.1300A and 1.1309C. Based on the county's request. Well, let me ask you this. On the county's request for 30 days, do we think that's a reasonable amount of time?
If he's going to obtain that clearing permit and remove the fill, yes, sir.
Okay.
Which is what he has applied for. So I'm assuming that's the route that he wants to go, which is why I asked for that recommendation.
Okay. All right.
The clearing permit would be unnecessary if he intends to build at this point.
All right. Thank you, ma'am. I just wanted to clarify because, so what, that'd be 12-10 or 12-11? What's 30? 12-12? So the property need to be brought into compliance on or before December 12th of this year. In the event the property is not brought into compliance on or before December 12th, a $250 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That administrative fee needs to be paid regardless of whether the property is brought into compliance, and the property owner will have 30 days to pay that fine, or I'm sorry, that fee. All right, I've signed that order. Missing any others? Last call. No? All right, once I hit this gavel, we're not doing anything else. All right. All right, we're adjourned.